Hi guys, welcome back to Kitchen Court Cases, where we watch court in my kitchen. I hope you are all having a fabulous day today. It's Friday. I am so happy to see you all here. I would love to hear what you had for dinner in the chat. If you didn't like what you had for dinner, put what you wish you had for dinner. Um, we have ahead of us this evening. Don't promise things you can't deliver. Um, at least one, possibly two, emergency hearings that we're going to tune into that I find so interesting. There is going to be a bit of a homework assignment with one of these that I need your guys' help with. I am 100% convinced that we have seen the participants of this upcoming hearing in in a hearing, and I need to know where. Maybe it was just me, but I'm sure some of you guys were along for the ride. So, also, I will get everybody points, extra points. And um yeah, this episode is a little bit, I don't know. I don't like to put trigger warnings. All the stuff we watch is triggering for the most part. But this is a divorce or custody hearing. It's an emergency custody hearing. It is not, however, a CPS related case, which makes it somewhat unique. So this is two parents, okay? And we're also talking about teenagers. We're not talking about kids, which is nice too. So I think there might be, yeah, anyways, we're gonna, okay, so what do we got? We got Domino's Pizza. Um, I I had some wonton soup. Oh, and I got a fortune cookie with my soup tonight. And guess what my fortune cookie says? I'm so excited. It says, your efforts will be worthwhile. How exciting! I bet you couldn't see. Oh, excuse me, fudge. That's what I said, fudge. Anyways, so let's look at some of my efforts and see if they are worthwhile. I hope you guys enjoy this. I don't know how the Zoom call goes. I'm going to pop in there as I always do. But oh, there's going to be some feistiness with the lawyers, and where we're really going to be seeing a lot of drama is with mom and her face. She has a real hard time controlling her emotions. So, without further ado, may I present to you an a motion for emergency hearing on kitchen court cases. This is the judge, Judge Stacy Heydrich.
Okay. All right, I'm gonna let everybody in. Where is everybody? Participants, admit all. All right, good afternoon, everybody. Can you all hear me okay?
Yes, Judge.
All right. This is Lee versus Hightower. This is an emergency motion filed by the guardian. So is everybody ready?
So as I get myself settled on the screen here and they get themselves settled, let's just to anybody just joining us, welcome. We're about to watch an emergency hearing, but the really unique thing that you have to remember here, folks, is this hearing was not initiated by neither mom nor dad, but the GAL, the guardian ad litem. That's rare to me. I've watched a lot of court cases, a lot of CPS cases, etc., and this is a unique circumstance. What we're gonna find, so just above me right here, this is the mom's lawyer. Dad's lawyer is sitting beside her with the red hair. That's dad on the bottom. Mom's blanked out at the top. You can't barely see her right now. And that's mom's new husband up at the very top. The GAL is Dawn Taylor. And the other two are assistants or like paralegals. And then there's this awesome girl down here on the screen. Her name is Kitchen Court Cases. Oh, hi, Keeper. Welcome. I hope you're doing well. We've all been thinking of you. And everybody who's here, hello. I'm so happy you're here, but Keeper especially, we're sending very positive and healing thoughts to you. Judge Kim would absolutely be booting Kelly Lee many times over for this. Judge Heydrich is pretty, I don't know. I don't know. I want you guys to tell me. I want to know what we need to call her as a judge, and I want to know what you think of her. You need to settle down then, Keeper. Follow the doctor's orders, please. It's so important to take care of yourself, and we all want you to heal very fast, but that takes time. So, in the meantime, you can enjoy this contentious custody hearing because I know that will probably relax you. Unlike the average person, we all love court. So let us continue. And yeah, so anyways, Jennifer Yoxall right here above me, she's to be watched for. She's not happy with the GAL. Her and the GAL are being with each other. So let's continue.
Ready to proceed?
Yes.
And are there any witnesses who we need to put in a breakout room?
Your Honor, it looks like we might have to sequester witnesses. I see people here besides the parties.
Okay, so let's see who everybody is. Well, actually, let's see. Counsel, Ms. Shoemaker, do you have your client?
Your Honor, my client is here. His
Mr.
Neil, and Bonnie Stinson is my associate.
Okay, very good. All right, then Ms. Yoxall, your client is Ms. Lee?
Correct, Your Honor.
Okay.
Thank you, Bazia. I appreciate that so much. You guys are awesome.
Is another possible witness if we need her.
Okay, then I'm going to go ahead and put the two potential witnesses into a separate breakout room. Let's see.
That reminds me.
And then Christy Johnson.
I heard somebody. I'm trying to let it.
We'll call you back when, or bring you back when we are ready. So
Such before we.
I apologize for interrupting, Your Honor. My apologies. That was my bad. Judge Middleton said something the other day where he was like, "Oh, I would put you in the breakout room, but there's already somebody in the breakout room." And I was like, "I think you can make more than one breakout room. I'm sure I've seen people make like 30 breakout rooms. I guarantee it." It would be funny if some people were like under the impression that you could only have one breakout room. Anyways, uh, let's continue. And Neil does look mad. Neil is mad. Neil's the ex-husband in this case. Oh, Prissy, you found it. Woo! That's exciting. Yes, ladies and gentlemen, that has happened. Memberships are open. The kitchen is open for resumes being accepted. We can see Prissy as our first line cook.
Begin. I don't know who hired the court reporter for today's hearing, but the court reporter's emailing me. So if y'all can make sure that they have the right Zoom information, please.
I did not hire a court reporter today.
Ms. Yaxel, yes, I can't hear you.
I'm so sorry, Judge. We did. I'm just asking Christy to go ahead and send that latest login because there was some confusion with the login information.
Okay. All right, let me move Mr. Lee and Miss Belmont.
Thank you guys so much. I'm so excited. Ah, Brittany, Laura, Valentino, you guys rock. Seriously.
It looks like the court reporter's on, Your Honor.
Thank you. And Miss Belmont, where are you?
Welcome, Chris Sampson.
There she is. All right. So the witnesses need to accept the invitation to go into that other room.
Thank you, Gracie T. Thank you all.
Okay, Ismary is with me, Tess is with me, and Mohini is with me. So that should cover everybody. And we have the court reporter. Okay, very good. All right. Ms. Taylor, let's start with you since
Monica.
since you filed a motion.
Do you want me just to sort of give an opening type statement?
Yeah, that would be great.
Okay. So I originally was contacted by, I guess, Mr. Hightower regarding this affidavit of election situation with Henry and Ansley. I, have had a lot of court and, other things. And so I was they were about to go into spring break. And so.
Thank you, Rachel. Thank you, Donna. Thank you all. Thank you, My Crazy Life. You guys are all amazing. Rachel, yours did. I see it. You are in. Oh, Gracie, you are too sweet. Oh my God. Thank you so much. MB, yay, yay, yay. You guys, we are going to have the coolest club. Yes. It's so amazing. Thank you so much, you guys. It means so, so much. And I appreciate you all. Seriously. Incredible, incredible, incredible. We are the cool kids. At least in my kitchen, we all are. And I love you all. Thank you so much. This is such a fun. I love this. I love hanging out with you guys. My Nana literally thinks I'm crazy, but that's okay. And you know what? That fortune cookie is so right, and it is true. We are going places, people, and you're all coming with me, and we're gonna have fun. So, let's keep watching. Keep in mind, the lady talking, Dawn Taylor. Whew, I gotta keep on the ball like a news reporter. Back to the story at hand. Dawn Taylor has brought this motion before the judge because she has received a disturbing phone call from Neil Hightower in regards to this issue. I'm kidding. I love you guys so much. Okay, let's keep going. Well, no, she would definitely not prefer me to be drinking and going crazy. But I do go crazy a lot, so, I'm dancing in the kitchen all the time. Oh, thank you guys so much.
So I kept thinking, oh, I'll go down to their school, but didn't have a chance to get down there because I like to do that and see them on a neutral, territory, just because it makes everyone feel better. But I couldn't accomplish it. And so then when
So let me ask, the allegation
is
allegation is that they were forced into the election. Is that what I'm?
Force is a word, as a former prosecutor, force has many, meanings. But so, yes, sort of, and, when I say confined, not falsely imprisoned. I mean, I think if they had fought their way out, they could have gotten out. But, sort of kept in a room and, that Kelly hosted and would not allow them to go until they, essentially until they caved and signed. And, if they had not caved, would they have remained in the room? Possibly. I think that they were allowed to speak to each other. And then, but, she's the parent. She's, they wanted to go to their friends, the activities that they had. And she was not allowing it until they, complied.
Okay.
And then, so they did and just, said, well, we'll sign it, doesn't, Ansley and Henry both said, we did it to get out of the room. And it basically, was, we want 50-50. You may or may not know that there are 2 previous affidavits in this case signed by the children that Mr. Hightower submitted. And independent of those, I have communicated with them on multiple occasions about their desires, at which we've been pending for 3 years. So I've spoken to them over the years several times, and they don't want 50-50. So that wasn't their desire. That was pre-written, and they were made to sign. So that is. Was concerning, it was concerning to me. It's Henry is a child who has, of the 3 children, Bradley is now 18, about to graduate and go to college. He was 15 when I met him. Henry was the one who would give me, who shared with me the least. He was the child, as I've been with these children, who always was the most neutral. Had the least issues from a parenting perspective, objectively, you know what I mean? Like just Bradley is on the spectrum and has some things, but Henry and Ansley had their own things from the beginning, and Henry's just always been an easier child, I think, for everyone to parent, and also just more compliant and that kind of thing. And he was very neutral, and just never has given me much, opinions, except to state his opinion. He doesn't elaborate. So when I met with him in my office separately from everyone, he put his head in his hands and he said he gets headaches. It's getting to be too much. He thinks he's just been pushing it down and he just can't do that anymore. He's coming home. Mr. Lee wasn't present in the home. They've been separated physically, and mom is kind of, guilting him into come watch a movie with me. And I think sharing information that he doesn't need to be part of. Not, mental abuse information, but just leaning on him as an emotional resource to fill up her emotional needs. And he's overwhelmed.
What did he say anything in particular about the affidavit?
Yeah, he said the children were both very consistent. I believe Ansley, I don't take notes with them because I just think it makes them uncomfortable. But I think Ansley had to be picked up, and the conversation started with her in the car. And then Henry was there and wanted to go, and he was the first in the room, and then Ansley. And so that's how I think that went. But I didn't, they converged at the house together, and then were,
But they each child separately said to you that they felt forced,
did not want to sign it,
okay,
not allowed to leave. And Wendy Fritz, so when Neil alerted me, Wendy Fritz, who is Ansley's counselor.
Sorry, guys. Thank you so much, everybody, for being here. And, people are mentioning in the chat how this is a family. It really is a family. This is a neighborhood expression of care. I like to think about it. We care about each other very much. We've all come together over our weird obsession with court. Nobody in our families understands. They think we're crazy, but we don't think we're all crazy. Now, I want to put out a little PSA. Yet again, I have experience in this. I'm a divorced mother of a teenager. That sounds weird. That's not exactly my normal descriptors I use, but that's technically true. And I don't like kids being involved in court. I don't like children signing affidavits. I don't even like them talking to the judge, to be frank with you. And what I say is, for shame to the lawyers. Welcome, Doc. Welcome, welcome. At the end, I'll read off everybody's name that became a member today. So, CRD, thank you. In case I missed anybody, I will do a reread of every new member today. That'll be my thing. But I am just already, we are 10 minutes in, and most of that's been just getting settled, And I think, for shame on these lawyers, to be frank with you. I'm not a lawyer. I'm not a judge. I don't know what the needs are necessarily. However, I'm a mother and I was a child. I'm a retired child now. And I don't think the probative value in most cases is that good comparatively to what the impact on the child, basically. Hi guys, hi Leather and Lashes, everybody. Thank you all for being here. Let's just keep this as a reminder for ourselves. Sometimes you feel yourself getting out of control, though. You're caught up in emotion, and you're a person too. So this is just a reminder to step back, take a deep breath, and reach out to adults that can help support you. Thank you, Laura. Thank you, Laura. You're amazing. That's awesome. Thank you. But seriously, reach out to adults who can help you get through these things with a divorce. Really try not to lean on your kids in that way. It's easy because they're there, but it's not the right way. So anyways, let's continue. And again, I guess what I'm saying is, I know in some family law cases, children need to testify, children need to be there to give evidence, but in most cases, I think that I just don't know why kids would need to sign an affidavit. I just don't get it. But anyways, let's continue. I love you all. Thank you so much for the gifted memberships, Laura. Thank you all for being here. Seriously, dreams come true. Even in Canada.
Counselor of some time, who, I stay in, communication with, has, because of some of Ansley's issues, texted me or emailed me and said, Ansley needs you to come see her. And so on that day, and so Ansley had shared with Wendy the same conversation. I spoke to Wendy
I got
this
out
morning.
Hold on, it's okay. We'll fix
shared
it.
the same thing she had told me.
I had to type.
which was the being forced
about the affidavit and being kept in the room
This
and
is what
not allowed
happens
to
when I get all
leave.
excited on myself.
And they were in session, and Wendy said, Ansley wants you to come see her. So then I called Neil, and he had him there the next day to my office.
to the therapist. To the therapist or to your office? Okay.
No. So
Okay.
Ansley was in the therapist's office.
When she said it. Okay.
And so Ms. Fritz heard it first, right, from Ansley. She said, Ansley wants you to come see her. And then I asked Neil to come bring them because they were on spring break, so they could come the next day. And so, yeah, they were, I mean, you know, these children aren't easily traumatized because of what they've, I think, experienced in their lives. But Henry was really the one I was most concerned about in my meeting. I met with them separately. And with Henry, I mean, he looks defeated. He looked exhausted.
How old is he?
Henry is 16,
Okay.
I believe.
All right.
And he asked me for a counselor. He said, I think it would help me to see somebody. I said, I agree. I said, I'll get recommendations out. I asked Ms. Fritz for recommendations, and within the practice she's in, I sent some ones that I refer people to, both in my, you know, practice as a, you know, just, yes. And men, you know, he wanted a man. You know, Bradley has had a counselor, Dr. Scott Davis, who I think is great for Bradley. I think.
How old is Bradley?
18. He's about to
That's
graduate.
right. Okay.
And I think that he, you know, I think he needs a separate counselor. I just think that every counselor needs to start fresh with these folks, both with the parents and the children, given the more in my opinion, the more eyes on it, the better. And that's why I think it's important to Henry to have a different counselor than his brother.
Understood.
And
what are you recommending as a result of this that I do?
I am asking for you to suspend the visitation with mom pending her forensic psychological evaluation, and that she comply with all treatment recommended. And as soon as she gets it, we can, you know, phase back in, because I just think that, and I have feared for a long time that as we approach, hopefully, the end of this litigation, I do believe that she is, I mean, I would use the word aggressively getting more defiant of the court orders. She has stopped taking Ansley to counseling. She doesn't pay for counseling despite the court order because she doesn't like that Ms. Fritz, you know, has, I believe, accurately assessed the situation, which means that Ms. Fritz sees to some degree what I see with Kelly and has independently seen that. Not to say that Neil doesn't have issues, and I've never said that. I've testified, you know, under oath that he has his own issues, but the issues that are affecting the best interest of the children in a way that I think requires the court's intervention is what Miss Lee is doing. So she's stopped paying for Bradley's, you know, Mr. Hightower is paying. That's why they're going. Ms. Lee likes Dr. Davis. She believes that he aligns with her feeling that children should not be allowed to select and elect, you know, and give an opinion on time with each parent. Dr. Davis does adamantly feel that way. And so that is why Kelly, you know, likes that and wants him. Fine, perfectly fine, but she's also not paying him. So, you know, the children are in counseling because Neil is paying, which I'm very, you know, glad for the children about. But the court order says she's got to pay. And, you know, she's recently gotten the nurse practitioner for the pediatrician to not even sign, I think it's just a letter written where she's weighing in on there should be a second opinion with Ansley because Kelly doesn't want Wendy Fritz to continue and has done everything she could to try to get her off, as she's doing with me, where she's, you know, this motion is saying I'm acting in bad faith and I have unclean hands. This is Miss Lee's MO. I mean, that's how she tries to get people out of her case when they don't agree with what she wants. Dr. Levitt has resigned. She will not continue. My understanding, and I have not, Neil will have to tell you this, but I understand that there was a withholding of Bradley's medication. I don't have firsthand knowledge of that at this point. Miss Lee was not giving the medication because Bradley wouldn't come see her.
Ms.
Again.
Yoxel, you'll get a chance to respond, I promise. All right, go ahead.
So though, I mean, my main concern has been, because there's in this case, more than any other I have seen, there is always something. But until this, I have always thought that these children have survived in this highly contested custodial situation, well, with the exception of Ansley, relatively well. And Henry was sort of always my marker for that, because Bradley is on the spectrum. Bradley, has some more challenges to deal with things.
But he's also aged out.
But but 3 years, I've been
sure.
Yeah. And so that, that's my point, is only that, Henry was always okay. And when Henry came, he was not okay. And, he could have had 3 counseling sessions by now, but you know what? He's not, Miss Lee doesn't want these other neutral counselors. She wants to go to Dr. Davis, which I specifically asked not to happen because it's just not appropriate in this case or in their best interest. And Henry asked me for a separate counselor. He didn't want to go to his brother's counselor.
And Davis is who Bradley sees.
Right.
Okay.
But she won't do it. And it hadn't happened because she has final decision over medical, which is what I'm asking you to change as well, to allow Mr. Hightower to set up the counselor. And I've told Henry, and Henry will do this, and everybody knows it. I said, Henry, you're going to have to maybe go to 2 or 3 to get a connection. Same with Ansley. Ansley had to do the same thing. And if you connect, it will help you, but you may not like the first one. You may dislike the first or second one. And he said, I understand. And we've given him options. I mean, I've given options. And Henry understands that. But he's not getting it.
16, you said?
Yes.
Yeah, okay. Mom is mouthing that he's 15.
Okay. Well, I can look. I haven't.
He's 15 and a half. So, I mean, I think it's fair to say that he's almost 16.
Yeah.
Okay.
It's as we've stopped using full DOBs, I've kind of stopped looking as much because you can't just look at that. But yes.
Okay.
Even though I do have his.
Understood. Okay. Anything else?
No,
No.
not for me.
All right.
So again, I'm sorry, Judge. I wanted to make clear. I do want, for a temporary basis, for Mr. Hightower to take over the counseling provider.
Well, if he would have final decision-making authority on medical, that would come with that.
Of course. And that's great. I just think my point is the rest of it, I'm okay with. It would just be the psychological, if you wanted to piece that out.
Okay. Is there, refresh my memory, has she already been ordered to undergo a psychological evaluation?
No.
Okay.
No.
Okay. All right.
And I will tell you, I am aware, and they're right. I did try to call Kelly's psychologist a while back, and I just haven't spoken to her. She has never been engaged in a forensic way. In other words,
right.
Yeah. And so I haven't seen a huge value in doing that, because to me, this case cries out for, and I have repeatedly asked Mom and her attorney for her to agree to a full forensic psychological. And I even, said we would, maybe even have some things where Mr. Hightower doesn't get it, because I think he would use it against her in the litigation. But she has not agreed, and I haven't, yeah.
Okay. All right, let me hear from the attorneys. Miss Shoemaker, do you want to add anything to what the guardian has already stated?
The only thing I would add to what the guardian said, and my client can testify.
Sorry, Ms. Shoemaker, I would like to speak first. This is Kitchen Court Cases for the YouTube community. I would like to know how everybody feels so far about this guardian ad litem bringing this forward. To me, this is intense. Never seen this before. Also, is mom chewing gum and just like sobbing or crying throughout? I get that it's serious. I get it, dude. I get it. I'm also, for anybody new here, I have ADD here, like up the yin yang, and with that comes rejection sensitivity, dysphoria. Like I get it. I'm an emotional person. And I've done some crazy stuff, but Tupac, thank you so much. You guys are amazing, seriously. Oh, the one sticker I've got so far says better than I deserve, you guys. I'm getting one that says no porch. Oh, so exciting. Anyways, so below me here, this is Dad's lawyer. I know this is like pile on already because usually the GAL doesn't act like this. But hi Jonathan. It is the GAL's job, but I think you guys will probably agree with me that they are not usually this um forward. Are you going? Okay, let's keep watching.
To this, but sometime in mid-April, Miss Lee received the new anti-seizure medication for Bradley, and my client asked, to get it from her on April 14th, on April 19th, April 20th, and she refused to give it to Dad, insisting that Bradley had to come to her house and have a conversation with her before she would give it over. Now, it's my understanding that this week, after the guardian filed her motion, Mom did give the medication to Dad. So that's also concerning for us. That again, it's really manipulation against the children, and we think it's very detrimental to the children.
If that is true, I would agree. So, all right. Anything else, Ms. Shoemaker? I'm sorry, I didn't mean to cut you off.
No, Your Honor.
Okay. Ms. Yoxall?
Thank you, Judge. Okay, I'm going to start backwards. So with what Ms. Shoemaker said. Okay, so Bradley has epilepsy. He's on Keppra. I have complained to the guardian multiple times that Bradley is not taking that medicine at Dad's house. There is a new tablet, exactly the same dosage, except it's an extra lot. They call it extended release.
Yeah.
So it's taking it twice a day. And random comment, but I have a dog that suffers from seizures, and so I'm very well familiar with Keppra. My sister died of cancer that went to her brain. Very well familiar with Keppra. So she wasn't withholding anything that Mr. Hightower didn't have. The only reason why she suggested that Bradley come to her home is because my client is a LRN. She's a nurse, and she wanted to make sure he understood the medication, considering the fact that there's been a history of him not taking it at Dad's. So that's that. This is, what I like to call smoke and mirrors and trying to paint a horrible picture of something that's not necessarily correct. So, and I'm going to, like I said, I'm going to move backwards. The idea of, now I appreciate Ms. Taylor admitting that she has not talked to the professionals that my client sees, but my clients had to sign more than one waiver because of the time lapse, of Ms. Taylor not speaking to them. I have asked Ms. Taylor repeatedly to speak to these people, emails, calls, but to no avail. Now, let's talk about this affidavit of election. If you look at the timeline, Your Honor, and I'm just kind of run this by you because there was spring break. There was also the fact that the parties do share week on, week off. The affidavits were signed March 25th. The evidence is going to show, and it's in my motion, that there were tons of communication between the children during this time period. Nobody was held in a room for 2 hours. And Ms. Taylor even admits that my client spoke to them individually and together. And even if we were to say she forced them to sign this, it's not even valid per OCGA with respect 1993 with respect to affidavits, because Mr. Hightower not only filed one but two. and nothing in there said anything bad about dad, that he's a piece of crap. All it said was 50-50. And that actually isn't harmful to Mr. Hightower. That's just saying, like, let's just continue this, but fix whatever these problems are between us.
All right,
But-
hold on one second. I have a question. You said the affidavits aren't the ones that were signed March 25th are not valid?
Technically, they're not. I can't submit them to the court for evidence, in the sense that because there was other affidavits filed, you're not allowed to file more than one affidavit every 2 years in a case. And this case has been pending 3 years. There's actually 2 affidavits filed by Mr. Hightower.
When were dad's filed?
They were signed in December 2021, right before Christmas, but they were not filed until January 2022. And then the other ones were filed with the other ones were filed with the original answer and counterclaim filed by Mr. Hightower's first attorney as well. And that would have been, I think, September 2020 or August 2020. So we're okay. So, but irrespective of that, the kids were with Mr. Hightower from March 27th. So that this affidavit hostage situation takes place March 25th. The kids are with Mr. Hightower March 27th to April 12th. I haven't heard anything about these affidavits or any issues. Or then the kids are back with my client April 12th through April 24th. During those time periods, I'd like the court to take notice of this. Miss Ansley, the daughter, the youngest, who has probably the most issues, went to see Wendy. That's this counselor, right? Wendy, for it's on March 29th, April 19th, April 26th. I guess I'm just calling into question the motive and how, the outcry was first by Mr. Hightower, who benefits from this outcry, who benefits from perhaps twisting the story as if, oh, you were forced and stuck in a room. I submitted my.
Okay, so, welcome. Thank you so much. I don't know how to, how many minutes? Oh, we're in. Bitches against bullshit. Thank you for becoming a line cook. My kitchen is so well staffed. Okay, here's a quick rundown. I lost like 6 viewers there. Here's a quick rundown of what's going on. Mom above me, dad beside me. Okay. Mom, that's the good attorney, guardian ad litem. The guardian ad litem brought this motion for emergency temporary custody orders from against mom because of a multitude of things. They are nearing the end of their divorce, and the children signed a affidavit of intent, I guess, allegedly under coercion from mom. Dad didn't have them sign anything. It was mom, and while they were at her house. And I am absolutely positive we have seen these people before, you guys. I swear to God, it's either, okay, so what happened was she was arrested a month and a half or so ago for assaulting her step daughter. I swear to God, it was in a TPO hearing in DeKalb, because that's where we are. No, we're in Fulton. I can't remember. We're in Georgia. Anyways, if anybody can find this first hearing, I remember her, and you'll remember her afterwards when she starts freaking out and talking. But so right now, what's odd about this situation is that, oh, bartender, I should have some of those. What's odd about this situation is that usually the GAL speaks last. It goes the like motioning party, and then the parents' lawyers, whoever was opposite of that. It might have been Judge Manning. Like, they all run together a little bit now, but I will swear to it that we've seen it. And I wrote that, like that I knew. I even think, yeah, like seriously. I believe it was like a TPO hearing or either that or like a first appearance, possibly, where she was arrested and brought in and given bond, maybe. Oh, it could have been in front of Judge Lal. I'm getting a vibe of that, but that might just be totally whatever. Okay. let's continue on. It is a crap show. It gets worse, to be honest with you, but it also gets spicier. This lawyer down here, the mom's lawyer, she's not happy at all with the situation. And Judge Heydrich has to reprimand them. So let's keep going.
My response, Your Honor, which does have text messages. It helps with the timeline of the kids. They were going out. Mom was taking all these boys to Waffle House the next day. There was nothing in there that sounded like that mom is holding them hostage. The other thing I'd like to say is that we're here on an emergency motion, and I hate to like say the same argument as last time, but this is not an emergency. This is a typical, unfortunately typical, and Your Honor, you know this. This is a high conflict case that has been high conflict for over 10 years. These parties cannot get along. And to be fair, both of them are unreasonable. I've spent hours reading their Our Family Wizard. I have, 10-page dissertations from Mr. Hightower, not agreeing to basic stuff. I've got 10-page dissertation from my client, not agreeing to reasonable stuff. And that's where we are with this. These are two people that just can't get along and can't put the children first. Miss Taylor says that the children were so distressed. I have more text messages. I have witnesses to say they went on vacations together. They did all these other things, but I mean, how can they be so distressed from this if they're doing all these activities and talking to their mom and telling them they want to go see Heather's at the high school that's being performed and going to football games and lacrosse games together? FYI, because Miss Taylor has not followed up with other items I asked her to follow up with, my client is not separated from her husband. We are all familiar with what happened in February, which is an unfortunate situation.
Refresh my memory as to what happened. Because
February nugget.
Okay. Bradley was in the house.
Wait a minute. Who was arrested?
So my client was arrested.
Okay. Oh, that's right.
Between, I don't know, stepdaughter / dad, police came. They arrested her.
That's what sparked the other hearing.
Correct.
I remember.
But I submitted to the court through my response to the motion that my client's been exonerated. It's been expunged from her record. She's back with her husband. They're in counseling. Not that that really matters today, but they're working on whatever issues were going on there. And so they are together. So mom is not really.
I'm sorry. Just a little tidbit here, but February, March, April. Let's give it a 3 months. Let's just say it was the 1st of February and it's the end of April. Okay? You ever heard of the state of Georgia moving that quick on dealing with criminal indictments? Don't they have like a 2-year window to indict? And isn't it not up to the victim? Seriously. I know. I'm having frozen pizza because I'm here with you guys, and partly because when I go May 8th to 16th, I've got like a whole extravaganza of cooking, including a pizza oven and homemade dough, all the good stuff. But for today, I just had to do this. Seriously though, I've seen this woman before, and I feel for her. I feel for both of them, but I'm shocked at the level of snark that's happening right now between these lawyers, these two. I can't. Oh my God, I can't do it. Whatever, those two.
Relying on any of the children for emotional support, and even if she did, is this an emergency? Is this a reason to suspend visitation? Again, this is so extreme. When I complained that Mr. Hightower wasn't giving the medicine, or the fact that he has not encouraged Bradley once to reach out to mom, and when they were at a recent graduation event or high school event, Bradley completely ignored his mother, and dad didn't say a damn word, part of my language. So, I mean, that to me is atrocious, and in front of the other children. With respect to Dr. Davis, this man has been in practice for 20 years. He has a PsyD, which is equivalent, PhD. And if Henry doesn't like going to him, then he can go somewhere else. And also, Bradley's aged out. So I'm sorry, I have like kids and tennis people texting me. I apologize. Another thing I would say is that Bradley is aged out. He's not going to Dr. Davis anymore. So it's not like the two of them are going to be sitting there together, you know, kibitzing about what's going on there.
But wait a minute. The oldest child is not getting any counseling now?
I believe he's almost done with it.
No, I mean, I haven't checked in with Dr. Davis. When I spoke to Bradley, he asked me he was going every week. He asked me for every 2 weeks. But of course, I can't accomplish that, right? If mom won't agree with anything that I say. So I just don't, I mean, that's what Bradley wants. I can't help him. So I don't know what is happening right now, but I'm telling you.
Does mom take him to Dr. Davis?
She does. And what I will say is Dr. Davis is paid up. So that was an incorrect statement by Ms. Taylor. He has been paid up. And,
when did that just happen recently?
I believe last week. Yeah.
After this motion was filed, perhaps?
Not to my understanding. I believe it was the 20th. He was paid up, but I can pull the receipt, Your Honor, if you want to see that, if that's really important today. But the other thing that I would like to say is that my client is very well educated. She is always made the medical decisions and spotted issues with these children. I mean, I've complained to the guardian when when Ansley came back with this disgusting rash all over her. We sent pictures to her, but that wasn't a big deal to the guardian. That dad didn't take her to the doctor. Dad doesn't take her to the doctor. And now all of a sudden this year he's interested in that. But that's fine, better late than never. But my client simply asked for a second opinion because in her opinion, as a nurse and the mother of this child, she's not improving under the care of this woman. This is a child that shoplifts, that cuts herself, that since a very early age of 8 or 9 sent sexual pictures to people online and through Roblox and still continues to send sexual pictures to her boyfriend. And mom continuously gets calls that, hey, just want to let you know your daughter sent something again, or she's using Snapchat and it got deleted, it gets deleted. So you can't really track it on the phone if you're trying to track. To me, those are very serious issues. And I feel like, and look, I've worked with Miss Taylor before. I think she's a great person. So I'm not here trying to attack her, but I feel that it's reached a point where Kelly can do no right and Neil can do no wrong. And I'm sorry to call them by their first names. We live in the same neighborhood and our kids go to school together. But either way, Your Honor, the bottom line is I don't think that this is fair. I don't think this is an emergency. If the court's inclined to order a psychological evaluation of my client, I would ask that it be done of both parties. But what I will say is that I don't think that Ms. Taylor is requesting this in good faith when she hasn't even spoken to the health professionals dealing with Miss Lee at this point. I just think that this is her opinion as a lay person, only as a lawyer, and I hate to say it, I can't make opinions on medical things either. I don't have that background, but I don't believe that she's done the sufficient legwork to do so. And the letter that I submitted in my motion also, Your Honor, is from the pediatricians that's been seeing these children since they were born. And if they think that it's okay to have a second opinion, what is the big deal? I mean, why is Mr. Hightower afraid of a second opinion? Is it going to come back that something horrible is coming on? I mean, it just doesn't make sense. And the person that Wendy, that Miss Taylor says that, oh, Hansley loves Wendy and Mr. Hightower loves Wendy. This is someone that's not even fully licensed and that is under the supervision of someone else. So why not go to someone more experienced that's more well-versed in A, self-harm, B, shoplifting and lying. And we all know that shoplifting is not necessarily about needing to steal something. There's a mental psychosis behind that. And also, dealing with this whole, sending the new pictures, this overly sexualized behavior that's been going on for years and not getting resolved. And now, and the latest, which I know Miss Taylor disputes and Mr. Hightower, but Ansley has dropped a significant amount of weight. She's still technically safe on the BMI chart at the pediatrician, but she's still being monitored. She doesn't do any sort of activities that would warrant such a drop in weight. For instance, my daughter does about 20 hours a week of gymnastics. She plays soccer and she does jujitsu and never sits still. So for her, yeah, she is a stick figure. But when you do an hour or two ballet and no other activities, it doesn't warrant to me how you're dropping a tremendous amount of weight at that age. And so I don't think that that's an unreasonable question or investigation, and it's still ongoing. So I think that my position is that when I present these issues, and I think I present them rationally and not, I try not to be argumentative, like I said, get along with Dawn. I think she's great. But in this particular situation, I feel like, she's shut off and just not listening to what I'm saying and not willing to investigate what I've mentioned. And I think this motion shows that, this is not an emergency. Is it perhaps maybe bad judgment by mom, if it is at all, if this is even true that this was coerced? But at the end of the day, even if it's not valid, number one, and number two, these children love their mother. And I've got the text messages and I've got witnesses to tell the court about it. But to suspend visitation at the end of the year when they have activities, when they have, there's so many events that my client has planned. For instance, being in charge of the booster club for the football team for Henry, for her not to be able to go to these events, Mother's Day coming up. Bradley's graduating from high school, and although she attempted to communicate with Mr. Hightower about it, she's excluded from attending anything. How is that okay?
What do you mean she's excluded from attending?
Because Mr. Hightower is not going to allow her to attend
Bradley's graduation?
And that it's up to Bradley if Bradley's to see mom or do anything. So I think if my client did that, if roles were reversed, there'd be about 50 motions filed. What a horrible parent she is and how she's alienating and keeping the children from them. I just think this is a woman that raised this child from birth. And it's just, it's really sad. This is a very sad situation. And I think that's why this just needs to get resolved, but not in an emergency hearing to strip anything left that my client has.
Your Honor, may I respond? Yeah, yes. Thank you. Wow, that was basically 3 years. So I think most of that is irrelevant. I have a lot to say about a lot of that. Ms. Yaxall is a great witness for Ms. Lee, but she's not a witness, and she has not individually spoken to those people. I've spoken to Dr. Rodbell's office about Ansley's issues. And they have been very clear.
Sakes, for sakes. Oh, do you know how hard I thought about what I was gonna say? I'm sorry. Guys, what would I say to my daughter? Knock it off. I didn't need any of that shite in the chat, to be honest. Everybody, am I still muted? No. But that's the reality. I read it all. I see it all. I see it from chat room to chat room to chat room. I don't really want it here. What I want is for people to have to, if you come here and there's somebody here that you don't like, what I would love for you to do is one up each other to be the bigger person and try not to be triggered by the other person. That would be what I would enjoy. I go to chat rooms all the time where there's people there that I disagree with their opinions on things, where I'm diametrically opposed to things. However, I enjoy watching court. I enjoy talking to certain people, and I would urge you guys all to do the same. However, on the same token, if you want to come in here and complain about that in general without calling names out, then we're here to listen about all of those things. And that's okay. Like, that's not my concern. My concern is I don't want anybody feeling singled out or bullied except me. I'm the only one that has my name on the channel, so I'm the only one that signed up to take that. And so that's what's important to that. Also, tonight is like my first members night. Thank you, Jonathan. Look at you. I appreciate that. And it's not the vibe that my members would have. It's not the vibe we've had ever before. And I don't think it's the vibe we want going forward. And the reality is, I love all of you for different reasons. I see different cases and I think of different people. I hear different things and I'm automatically remembering certain things. There are people out here that I've known for years that I text with daily. There are some of you that I only say hi to in chat, but you're all very important and I care about you and I want you to have a safe space, but that is for everybody. And maybe that's difficult. Hey, I never said things would be easy here. That's the reality. Just like when you're adults and you want to have fun and have like really fun, like lots of fun, you got to have this crazy talk first so that you can have fun. So this is our talk. We're going to have fun, but we got to be pretty, we got to keep each other's names out of our mouths, basically. Anyways, I love you all, seriously. And I think like bullshit is fine. Bullshit is totally fine. But I don't want like high school in the chat. That's what I don't want. Because I hated high school. I was not cool. Okay. I'm cool now. Woo! Okay. Now that my rant is over, let's continue on with these lawyers fighting. They're the ones that are catty, guys, not us. Okay? I love you.
That they're watching her and she is fine. Ms. Lee wants to create issues because that gets her control. And this is her MO. Dr. Levitt will not continue because
Dr. Levitt won't continue with
parenting coordination. We asked
Okay.
her and it was consented that she would do parenting coordination. She's called me on multiple occasions and she has been exasperated with Miss Lee because Miss Lee will not follow any instructions. She will not stop bashing Mr. Neal in the sessions. She cannot control her emotions. She cannot focus on the issues. She has elaborated on, what she sees that Ms. Lee's issues are, and ultimately has agreed to come to the final hearing to testify. I mean, essentially what she's told me, which, if we're just arguing our case, is that she believes that Miss Lee has histrionic personality disorder or borderline personality disorder or a combination of both. And her hate for Mr. Hightower is so strong that she cannot put the children first. She can't mentally do it. Miss Yoxall is talking, about me as a person, saying that I am not aligning with the right person, and I'm very confused by it because Miss Yoxall and I have had conversations, very frank conversations. I'm not going to share those because I don't think it would be appropriate. But I think when you deal with Miss Lee, it's obvious. And my point with that is that the way that she has operated in this case, as you hear, she's paying for Dr. Davis because Davis aligns with her. And not even really. I mean, he doesn't say she should have primary custody and Mr. Hightower is toxic in any way, or that he's alienating. He doesn't say any of those things. He says, I suspect there's some talk over there that affects the children. But she likes what Dr. Lee says, and Dr. Lee adamantly disagrees with the state of the law as to children electing which mother knows. So okay, but the law is the law, and we're all sworn to abide by it. And so that's why he's paid. But Ansley, who has the most issues, right? Dr. Fritz told me, or Miss Fritz told me this morning that she's unpaid. So because Miss Yoxall brought my attention that Ms. Lee does not believe that Wendy is qualified to, Wendy Fritz is qualified to see Ansley, I communicated with Dr. Rodville, and I
Is Rodville the like general practitioner,
the
internal medicine pediatrician? Yeah. Okay.
for years and years. And Mr. Hightower, I know, also communicated with him independently. And I communicated with Wendy and asked her whether she felt, because at that point, Miss Lee had gone to Miss Fritz, Wendy, all of her supervisors, like had tried to get her removed, right? Had sort of not threatened her, but essentially, went over her head. Her Miss Fritz supervisors supported her. And when I had a conversation, I said, do you feel like you're connected with Ansley and you're making progress? Yes. Do you feel like you're qualified to handle the issues that Ansley has? Yes. I asked Ansley, do you want to continue to see Miss Fritz, and do you feel like she's helping you? Yes. And I think that short of this affidavit situation, everyone is in agreement that all of the things Ms. Yoxall mentioned about the things are about 2 years ago. I haven't heard that Ansley is cut recently. And the minute I walked into this case, she was sending nudes. She was 9 years old. So, what am I going to do about that, right?
She was 9 when she started doing that?
I believe she was 9 and just turned 10 immediately afterwards. That was happening on both parents and was always happening at both parents' home. One of the most, yeah.
Okay, and that is something that we need to talk about, and that's very serious too, guys, is that these people are acting all shocked, like, oh my God, 9-year-olds are using phones for nefarious purposes. Yeah, absolutely they are. Absolutely they are. At the age of 10, the average 10-year-old has absolutely already watched hardcore porn. Okay? And sorry to ruin anybody's bubbles, but that's true. So that's why the corn talk and all that stuff needs to happen beforehand, well before that. I know that's again upsetting to a lot of people, but age appropriate ways to approach things like that, things you can say to your children that are effective, that instead of it sounding judging are actually effective. Hey, you know that sometimes on the internet, there will be people that will tell you you're in trouble and that nobody will be able to help you. They might have pictures of you, or they might tell you that they have a secret of yours and that nobody will love you if you tell. I want you to know that that is not true. There is nobody on the internet that can do that to you, even if they make you think that. I am the master of the internet, and I will find that person. But I literally had that discussion with my daughter way early, and all her friends. You have to remove the power. The power of the internet comes from kids feeling alone, kids feeling like they can't ask for help or find, the right answer. So that is one way that you can age effectively talk to. Yeah, but it's online stranger danger, because your kids are gonna laugh if you're like, hey, are you careful on the internet? Do you make sure you know who you're talking to? That conversation means nothing. It literally means nothing. But when you have that conversation beforehand and then later on, all of a sudden, this happens, whatever. It's the scam that adults get taken by too. Oh, we've hacked your webcam and we're going to release it to your Facebook friends or whatever. Again, it's going to come to mind like, oh, right. This might be a lie, these are the things that you can empower your kids with age appropriate wise to keep them safe on the internet. If you tell them don't send pictures of yourself to anybody ever, that's not going to work. It's just not. So you need to explain to them that what you put on the internet is probably there forever and it can be found by other people. And so you need to be sure that you're comfortable with whatever you put on the internet. as opposed to making a judgment about what people are comfortable with or what people aren't comfortable with. You should probably talk about porn being fake and that it's not an actual representation of what a relationship is or what it looks like. However, it's a dramatization, just like a movie. And so it might be something good to watch or enjoyable, but it is not what you should model yourself after, nor what you should look for in a person as you get older. Those are messages that aren't often given, but they are, um, you know, probably would be effective. Power of the voodoo. I got all the power. I shit you not. I swear to God. And my daughter knows now, right? Like I've told her so early on. And then I act in public the same way I am here. I will step into a situation that a lot of people would say that's stupid to step into, but I do. But these are the things that you can be telling. So they're talking about a 9-year-old child doing this. And I'm not surprised one bit. Not one bit surprised. However, I think that those are practical things instead of sounding like a loser adult. That will maybe actually stick in your kid's head. And again, make it age appropriate. Like, oh, the other thing, like when, strangers out in public is not as big a deal, but back in the day, when I was trying to explain to my daughter about looking for help, I would tell her to go look for a mom with kids. Because if a child, I mean, if anybody comes up to me and asks me for help, I'm going to help them. And I have to trust that most mothers are. And so it used to be, oh, go to somebody in a uniform, but that's not the safest thing anymore. And that's something that they can use and lure. It's much harder to fake being a mother with multiple children. And I know it does happen in very sad cases, but it's rare. So that's who my daughter was young, would recommend her look for. Go find a mom with kids and tell her you need help. And I just rely on the fact that they would do what I would do. People are telling me about their talks from their parents. Don't do it till you're married. All those things. Getting in trouble for shaving. I was handed a book. It wasn't a bad book. It was like a totally here's a totally however it works book, but it's not quite the same. And again, it's mostly about just diffusing the danger points where no kid, no sex, no sex until after you have kids. That's a great one. Anyways, let's continue on. But I really wanted to preface this part of this with some practical tips that you can have to use if you have children. Oh, thank you, Monica. Her copay for therapy. Thank you so much. Seriously, that you can take and practically go, and you won't be the biggest idiot in the world. So, I love you guys. Let's continue on. She's about to start crying up here, if you notice. Also, I like the judge so far.
I mean, so one of the pictures that was being sent that I thought was very sexual, and she was clothed, she was sitting next to Miss Hightower in the car while she was taking the photo. So all of that, I mean, these are the people who I've spoken to. I've spoken to Ansley. I've seen the pictures. I had them all go to law enforcement. We got the phones. We had them completely download and investigate, and none of those photos had gone out, according to the law enforcement officers. So, I've done a lot. I know a lot. The pattern is there. Now I'm unethical and not in their best interest and, unclean hands. You know what I'm saying?
I
and
understand.
that's all fine. I get it. I would do the same thing. But the point is, this issue it's getting worse. And Henry, right, is that is what really has just put it over the edge for me. And that is why I believe it's an emergency, in the sense that these children are, I think, feeling hopeless in their situation, because here I am asking them their opinion and assuring them that their voice would be heard by the court. And, you know, we're in 2023, and, you know, so that there is a sense of hopelessness there. It is affecting their long-term best interest in a way that I think is becoming worse and worse, if that makes sense. It's not an emergency like, you know, defects needs to come in and.
No, I understand.
Thank
All
you.
right.
That's really all
All right. Ms. Shoemaker, do you want to chime in on anything? I do have one question though. Tell me about this issue of the medication. Mom says dad didn't give him the medication. Dad says mom didn't give him the medication. Do both parents have the medicine available at their homes?
Your Honor, let me just say this, and just so you know, I have communicated with Bradley about the medication from a year and a half ago, maybe. I'd have to look at my notes. But he doesn't like it. He didn't like the way it made him feel. And he, you know, he's now 18 plus. And so, you know, at some point, I mean, you know, I'm not, you know, at what point do we let children say how their bodies feel, right? As they're approaching that. And so I am aware that he wasn't taking it, but, you know,
At either parent's home.
I mean, I think mom was kind of, I don't know how mom was doing at her house, like whether she was, I mean, she can make you do things, right? Like she will, you know, as a parent, if you don't do this, I mean, I think that's legit. If you don't do this, you're going to, whatever. I know dad wasn't making him take it. There's no doubt. Bradley said he didn't want to take it. And so, you know, I don't, that's all I know about that. I don't know about the current situation.
Okay. All right, Ms. Shoemaker, anything you want to add?
Your Honor, and I'm happy to have my client testify about this, but I knew that Miss Lee received Bradley's new medication, a new Keppra medication, on or about the 1st of April. On Our Family Wizard on April 14th, she told Mr. Hightower that Bradley needs to come to her house to get his medication, and that he needed to come by the 15th. On April 19th, Mr. Hightower texted Miss Lee saying, can you please just drop off his medication? And she refused, saying, no, you need to send him to my house so I can discuss his healthcare needs with him. And at that point, Mr. Hightower had run out of the medication at his house. He did not have any more medication for Bradley at his house. And on April 20th, again, through Our Family Wizard, Dad again asked mom to drop off Bradley's medication and not force him to have to go over to her house because he doesn't feel comfortable. And that at that point, Bradley did want to start on the new medication. You know, that's, and my client can testify to that. And I also have the Our Family Wizard's messages if the court is inclined. You know, and my concern is that I do agree with the guardian that this is an emergency. And the reason it's an emergency is because things just keep getting worse. And mom, you know, has illustrated that she does not care what this court orders, and she's going to do what she wants to do, to the detriment of the children. The counseling for Ansley is very concerning, particularly if and it is, the guardian's right, it's hard to find the right fit, and we've got the right fit for a counselor, and mom has stopped taking Ansley to that counselor, has stopped paying the counselor. The only reason she's still going to the counselor is because dad takes Ansley, and Ansley's supposed to go every other week. So sometimes that falls on mom's week, sometimes it falls on dad's week, just depending on the schedule. And mom will not take her on her weeks. In fact, the most recent one was, I believe it was April 12th, which was mom's week, and mom did not take Ansley.
Is there anything in Our Family? I'll give you a chance, Ms. Yoxel. Hold on. Is there anything in Our Family Wizard where mom's saying to dad, I'm not going to take her to see Wendy Fritz?
No, Your Honor, I do not know for sure, but I do know that there were some text messages between mom and Miss Fritz. I think Miss Fritz actually shared with dad where mom said, I am not taking her.
Your Honor, you know, for a while.
I just need to respond.
Well, you know what? Hold on. You will be able to respond.
I
All
gotta
right,
clarify the date.
Go
I'm
ahead.
just
Go ahead.
because I have the timeline. Dad last minute scheduled an appointment during mom's time, which he's not supposed to do on the 12th. Mom immediately rescheduled it to the 17th and took her.
Okay.
So nonsense. And there is in our family wizard that discussion. Like, you can't tell me a couple hours before that there's an appointment on my time. Now, let me say something. Whenever mom makes appointments on dad's time, he will never agree to it. He will cancel it. He will complain to Dawn about the guardian about it. So she rescheduled it to a few days later. It is not true that she's not willing to take her. All she wants is a second opinion. This is not a travesty.
Okay. Yes, go ahead, Patty.
Yeah, I was just gonna say that it wasn't a last minute, and I've actually Ms. Fritz indicated that in the text messages that it's a standing appointment every other week, every other Wednesday. It's a standing appointment. It's not.
And why did mom, if it's a standing appointment every other week, why did mom have to change it? Ms. Yoxel.
I'm pulling the Our Family Wizard now so I can give you the exact information. Sorry, Judge. I didn't know that I was going to have to dispute this since it's not really in the motion.
Well, Your Honor, to be fair, Ms. Yoxel has brought up a ton of stuff that was not in the motion. And I'm just going to, I'll be brief just because I think the guardian did a good job of covering, what the issues are and the concerns are regarding the delay. My client specifically asked the guardian not to file this motion right away because the children were in mom's custody, and he was very concerned about what was going to happen or what mom's response would be and what she would do to the children if the guardian filed this motion while the children were in mom's custody.
Who has the kids now? Dad?
They're with dad.
Until when?
Yeah, I believe until I think next week they'll be back with mom.
Okay.
Monday. Your Honor, and I say that because early on in this case, and I believe this predates me, and I believe this was before the guardian got involved. I'm not specifically sure. The two older children, Bradley and Henry, did sign affidavits to live primarily with dad. When those affidavits were filed with the court, mom sat the children down and had a conversation with them about their affidavits. And why.
Again, this is beyond an emergency and what's going on. This is from 3 years ago. And I'm sorry, it was after the case was filed. And that's why I felt that this doesn't need to be heard today. This is all information.
Well, I decided it needed to be heard today. So
Your Honor, I'm telling you my opinion. And now Ms. Shoemaker's bringing up stuff from 3 years ago.
Your Honor, I bring it up.
I would really appreciate it if you all let me just call on each of the parties. I always let everybody speak, probably more than I should, but the interrupting is one of my pet peeves. So, okay. Ms. Shoemaker, you may continue.
Yeah, I bring that up to explain why the delay, and it was because my client specifically asked the guardian to not file this while the children were in mom's custody because of mom's prior conduct. We, in the fall, we had motions for contempt that we addressed with the court, and a senior judge heard those. So, Your Honor may not be as familiar with Ms. Lee and the things that she's done in contravention of the court orders. And what we're seeing as we get closer to a final is just worse and worse and worse. The therapy, there was a motion to compel arbitration, which I know has nothing to do with this, but she's not following court orders. We scheduled arbitration 5 times and she still didn't show up.
And I remember, when this came up last time, I remember expressing some concerns, but I didn't feel at that point that it had risen to the level to warrant a change. Is that right?
Yes, Your Honor.
But I expressly said I had some real concerns about mom's actions, which to me would be.
So, I just saw a question in the chat from Jonathan. Thank you. Which says, in Canada, which is where I am, do the courts allow children to choose who they live with? Now, I don't know the exact answer to that officially. Anecdotally, I know that it's very similar to the United States. And what's going on in this case and what's at issue here is not if the children should be allowed to choose. It's there is now an allegation that they were coerced into making the choice of 50-50 custody with mom as opposed to going with dad only because of that's what the GAL is saying. And so I think generally they do accept affidavits where the kids say, yes, this is who I want to live with, and they don't have to bring them into the court. But this is one of those cases where the GAL has said, hey, the children approached me and said that they did not feel good about signing this. And that's why it's being called into question. That's why this hearing was called. So, anyways, as I've said so many times tonight, thank you all for being here and part of our first ever night where we have memberships on the channel. I'm so glad that you guys are here. Please like the video if you haven't yet already and subscribe. Let's continue on. Also, she may have gone skiing down there, but look at my face is very light like that too. And it's just makeup sometimes if you're really light and then you put on makeup and anyways.
I were the mom in that situation, I'd be on my P's and Q's and I'd be dotting my I's and crossing my T's and making sure I didn't overstep an ounce, or a millimeter. So, okay. Anything else, Ms. Shoemaker?
No, Your Honor, I think that's sufficient.
Okay. Ms. Yoxel, anything else?
Yeah, I'm sorry. I'm not trying to beat a dead horse, but I do have the text messages. I see it's between Neil and Miss Fritz, and this is on April 12th. Miss Fritz says, just checking in on whether Ansley is coming to session tonight. And then Kelly, I believe it's Kelly, writes, no, she's not, as her father scheduled it on my time. I was only made aware less than 3 hours ago. You can bill him for the missed appointment. And she goes, it was not necessarily scheduled specifically for this week. I see Ansley every other week.
Yeah. How does mom not know that? If it's a standing appointment, it's not a situation of dad scheduling it on mom's time. It's always going to be on somebody's time.
And can I just say, if I can,
yes,
that prior to the Ansley has anorexia theme from Miss Lee, Mr. Hightower, and I said and testified at the contempt that he was the one who was more likely to miss those appointments, and he wasn't missing all of them. He would just, whatever. If there was a missed appointment, I heard about it from Miss Lee, and he had missed it. And I think one time he forgot anyway. And so I've admonished him about it. So because it was a standing appointment, wasn't creeping up on anybody. But before it was Miss Lee, I mean, that was one of her main things that he misses the appointments. So it's okay. You're assessing that correctly.
Okay. All right. Do y'all want to put up evidence? Do you want witnesses to testify, or you want me to decide this based on the arguments and everything I've heard?
I want you to decide it based on everything you've heard.
Okay.
Yeah, I have no objection to that.
Ms. Yoxel?
I just would ask and request that, did you read my response and the attachments? Because that's what I would have been provided.
Yes, I did. But let me do this. I'm going to take a quick break and I'm going to look at it again, given everything that I've heard, just to make sure I'm not missing something. So can y'all give me about 10 or 15 minutes?
Of course.
Yes.
Okay. Thank you so much.
Ladies and gentlemen, in the house, we have Credence and Mikey, who are amazing. Mikey, love you so much. They had an ad in Times Square today. Like, can you say that? No, I bet you can't. Don't worry, this isn't over. She comes right back. We're zipping ahead. I want you all to take this opportunity to go and make sure that you are already subscribed to the We Got a Case channel. we got a case. That is where we have been hanging out lately and where we see some of the funniest things. Thank you everyone for being here. Let's skip us ahead to the meat of this hearing. It gets crazier, if you can believe it.
Okay.
He's there right now on the call.
Well, I know, all right. I mean, it's just like you said, you know what the other position is going to be. I kind of suspect I know what their position is going to be. They're right. Everybody is going to have their own witnesses supporting each other's positions, but I'll be happy to hear from him briefly.
Well, Your Honor, while I understand that, I think he was there during the affidavit signing, and I think he's going to
Okay.
testify. If you don't need to hear from it, Judge, then
No, that's fine. No, that's fine. I'll be happy to hear from him.
Mr. Lee, raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please put your hand down. Are you currently married to Miss Lee?
Yes, I am.
Do you currently reside in the same home?
Yes, I do.
And I'm going to draw your attention to the events that occurred on March 25th. Were you around for those events?
Yes, I was.
Can you walk me through the day, that morning, what you guys did?
Sure. So that morning, my daughter Ellis had a lacrosse game at St. Pius, which she plays for the junior team or whatever it is. And at the time, so I drove her over there. I think her game was supposed to be at 10:15, but it didn't start till, gosh, at least after 11, because I was talking to a friend of mine from high school who actually, ironically, has a daughter on the team. At that time, Kelly and her daughter Ansley showed up at the game, and they watched the game with us. I think the game ended around 12:30-ish. And then we got in the car and headed back to the house. She and Ansley got in the car, and then Ellis and I got in another car because we had left earlier and went back to the house.
And then at the point you got back to the house, when did the conversation begin about these affidavits of election?
As far as my conversations with them, or as far as any conversations?
How did it begin? Did Miss?
Oh, okay. So we got,
Go ahead.
no, so we got back to the house. I guess it was around, I'd say close to 1:30. And then when we got back to the house, we were sitting down. I was talking with Ellis. I talked to Ansley. I talked to Henry for a little bit. Everybody was in, good spirits, having a good time. We were talking about what we were going to do that evening. And then I guess it was about probably, I don't even know, maybe an hour later, Kelly talked to Henry and Ansley privately for a few minutes. And then she said they were going out for a few minutes. They had to get something signed or something. I said, that's fine. And then I told Kelly that I was going to go ahead and take Ellis. She wanted to go get her nails done. And then her appointment was at 4:00. So by the time we were leaving, they were walking in the house. So, that was about it. And then we came home and had dinner, and they went and did their thing, and Kelly and I did our thing.
At any point during that time, did you hear Miss Lee say that they were not allowed to leave until they signed the paper?
No, I mean, Henry was in his room, and Ansley was out in the sunroom sitting there watching a movie. She was sitting with Ellis for a little while. So no, they were just, everybody was casual. I think Kelly was laying down actually upstairs in our bedroom for a little bit.
And did you ever see Kelly place the children in a room and not allow them to leave the room?
No.
And then did the kids participate in any activity? It was a Saturday, is that right?
Yes. Mm-hmm.
And did the kids then go on to their activities?
Oh yeah, yeah. I mean, they're when they're home on the weekends with us, they're always either in the house or going having sleepovers at other friends. It seems like more times than not they're over at our house. But judging by the amount of snacks and sodas and stuff we go through, but yeah, they all had their activities.
And did they ever voice to you that they felt compelled or under distress because they had to sign these papers?
No, they were. I mean, everybody was in really good spirits the whole day. I mean, I think everybody was just having a good time, and I didn't even know really what all was transpiring until I think it was after they went and had the stuff signed or whatever. Because again, it was just everything was kind of flowing around our house like normal.
And since that date, the kids have been at your home, correct?
Yes.
Have they expressed any distress or issues with mom because of this that you've noticed?
Not at all. I mean, honestly, Ansley tends to be a little quiet sometimes, but I mean, Ellis says the same thing, and they're sisters, so go figure. They're just teenagers. Henry kind of keeps to himself sometimes, just playing games with his friends. But everybody, we have dinners, and everything's fine.
And how long have you been married to Miss Lee?
Almost 5 years. God, that's weird to say.
And then would it be fair to say that you've spent half?
Actually, Mikey, you might know. I swear that we have seen these people before, and I'm sure it was probably with you. In This lady, Kelly Lee up top there, she got arrested for like beating up her stepdaughter. I'm sure it's in Georgia. Anyways, I'm looking for the the original video. I have no clue where it will be. I want you guys all to help me find that. But yeah, his testimony seems very coached, does it not? Like just exactly. And she's still crying up there. Anyways, here we go. I think it was a TPO hearing where the stepdad was like dropping it against her or something.
During that 5-year period, half that time with Ansley.
Oh, absolutely.
Obviously, Henry and Bradley too, correct?
Mm-hmm. Yeah.
And since Ansley's been attending counseling with Wendy Fritz, do you see an improvement?
My honest opinion, no, I don't. In fact, I will tell you without getting too elaborating, I'm personally concerned about Ansley for my own reasons, and so is her sister. She has been very concerned about her.
Concerned about what specifically?
Mostly her physical appearance and her overall weight. As recently as last Friday, Ellis pulled me aside when we were driving home in the car and whispered in my ear and said, "Please make sure she eats."
Sustain the objection. You can't testify as to what Ellis told you.
Oh, okay. Sorry. My apologies. But yes, I've been very concerned. I've seen a tremendous physical.
Sorry to cut you off. You said you went to dinner with her. Tell me what happened at that dinner that was concerning.
Well, we sat down. It was Ellis and I and Ansley, and then Kelly came and met us. I don't know, right after we pulled in at Pizza Cafe in Avondale. So I ordered what I tend to like to eat, which is the whatever they are, the pretzels, mozzarella pretzels. And got an order of 4 because figured there were 4 of us. Ellis ate 1, Kelly ate part of 1, I ate 1, and then Ansley had about a bite and then put it back. And I asked her, if it tasted fine. She's like, "It's fine."
Objection, hearsay.
Okay. You can only testify about what you observed, not what they told you.
She took a bite, put it back. And did she order anything else?
Yes, she ordered a calzone.
Did she eat it?
No. I put the entire thing in the box and took it home.
Have you seen other times recently where similar behavior where she either orders something and doesn't eat or isn't eating at home during meals?
Multiple times. I mean, it's eating out. It doesn't really matter what the food is. It's more, she just doesn't eat. And I'm not, I'm not saying that everybody's not a little different in the way that they eat, but not eating is different.
Okay.
And that's concerning to me.
All right. I have no further questions, Judge.
Okay, Cross.
Thank you, Your Honor. Mr. Lee, good afternoon. I'm Patricia Shoemaker.
Yes, how are you?
Good. Mr. Lee, do you recall an incident that occurred at your house on February 1st of 2023?
Yes, I do.
Miss Lee was drinking and there was an altercation?
There was a verbal altercation, yes.
And the police arrived at your house?
Yes.
And do you recall you told the police that Kelly, your wife, chased your daughter around the house and then into the bathroom, and she struck her using her two open palms to the top of the chest area? Do you recall telling them?
No, I did not say that.
Okay,
Nope.
so then the police are lying in their police report.
Their report was actually overstated, yes.
And then on February 8th, you recanted that statement, did you not?
I went back and I changed it once I saw what the statement was, because that's not what I told them.
You've been married to Miss Lee for 5 years, correct?
Yes. Mm-hmm.
She's very persuasive, isn't she?
I'm not sure what that means. I mean, as far as, I guess, I don't know. I mean,
You were aware that there was an emergency hearing filed after Miss Lee was arrested.
Sorry, objection.
What's the objection?
Cause for speculation. And truthfully, this all goes beyond the scope of direct, but I'm not going to be a pain in the butt and object over everything. But
I don't think you're limited anymore to what's been raised on direct. You got a thorough and sifting cross.
Thank you, Your Honor.
So, all right, go ahead. But with that being said, we don't need to be here all day for this.
Yes, Your Honor. Mr. Lee, you say that you're concerned about Ansley's weight. Have you seen her weight charts at the pediatrician? Yes,
I have not seen them, no.
So then you are not aware that actually at our last checkup, she went up in her weight.
I can't honestly say, with any certainty. I can only tell you what I see, and I can only tell you what I've observed over the past couple of years.
No further questions, Your Honor.
Okay. Any redirect? No. Okay.
no, Your Honor.
Any other witnesses?
Just one more, Miss Belmonte, who's in the waiting room, I believe.
Okay. She should be joining us in a moment.
Can you spell the name of your witness, Jennifer?
Yes, it's Susan and then Belmonte.
All right, let's, she needs to unmute. Oh, did we swear in Mr. Lee?
We did. I did.
Okay, good. All right, let's swear in Miss Belmont.
Yes. Miss Belmont, can you raise your right hand, please? Swear to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Okay. You can put your hand down. How do you know the parties?
I know Kelly and Neil because my daughter, Sophia Arnold, and their son, Henry Hightower, were boyfriend and girlfriend for most of 8th grade and until last Friday.
And you're aware that there's a guardian ad litem appointed in this case?
Yes.
Have you ever spoken with her?
No.
And have you had occasion to be in the presence of Miss Lee and her children and your children?
Together?
Yes.
Yes, I have.
To what extent?
When Sophia and Henry were together, she was frequently at their house, and I would go to pick her up and often just hang around and stay. We had Thanksgiving dinner with their family at Kelly and Jean's house, and we also, my husband and I were present at the dinner, and we also went to their lake house in January, and all 3 children were present at that weekend, as well as Ellis, Kelly's stepdaughter.
And where are you currently employed?
I am employed at Georgia Tech.
What's your title?
I'm the Assistant Director of Pre-Graduate Advising, and I am also a pre-teaching advisor.
Are you considered a mandatory reporter?
I am. I'm also a certified K-12 teacher, and I'm still currently licensed.
So if you were to witness anything endangering the children that would require reporting, you would be required to do so?
Yes.
And am I fair to presume that you've never done that?
I've never done that, no.
And when you were at the lake house, were you there for more than 24 hours?
Yes, we were there for, let's see, Saturday, Sunday, about 36 to 40. I don't exactly remember. I think we arrived on Friday. We arrived on Saturday and left on Monday morning. So
did you see
it's closer to 48.
Sorry to cut you off. Did you see any signs of distress of the children?
Distress and any kind of emotional, physical distress?
Correct.
Is that what, not really.
Not really.
I mean, not really in the sense that that's the first time I spent that much time with the whole family, and they're teenagers, so some of the things I saw having a teenage daughter just seemed normal teenagery stuff. Like they spent most of their time together. They didn't really hang out with us. We did go to an animal farm with Henry and Sophia for Sophia's birthday, and Ella, Ansley was with us as well, and I didn't see anything that would have made me feel that something was amiss. I didn't see Bradley. He spent most of the time up in his room. He came down to eat and then he went back up, so I didn't spend any time with Bradley.
Okay. And have you ever had your daughter spend time with Miss Lee?
Alone? Or
Yes.
just in general? Yes, several times. Sophia wanted to go to every football game to watch Henry, and there were times when I could not drive her, and Kelly would take her there. She took her to Gainesville. She would take her home from the games with Henry. So there were several times when she was with her by herself.
And have you ever felt that it was unsafe for your daughter to be with this family?
No, I would not have let her spend any time with Kelly or Neil if I had any sense that she was in danger. So.
Thank you so much. I have no further questions.
Do you have any questions, Cross?
No, Your Honor.
Okay. All right. Thank you so much. Any other evidence or witnesses, Ms. Yoxall? No. Okay.
No, Your Honor, just what's in my motion.
Okay. And I reviewed everything in the text messages and all that. I have one question for Dad I would like to ask. If we could swear him in. Dad, can you unmute? Raise your right hand. You solemnly swear affirm the testimony you will give the court with the truth, the whole truth, and nothing but the truth, so help you God?
I do.
When Ansley is with you during your parenting time, what have you observed with respect to her eating habits? Does she eat? Does she not eat? What does she do with that?
She does eat. In fact, every morning we get up and make breakfast, just her and I, while the boys are downstairs doing whatever they do. And so we have that every morning. She packs her lunch. I see what she brings in there. And then she usually helps me plan out dinner. That's her first question when she gets home, what's for dinner? So yeah, not only does she eat, she is actively involved in the making of the food, and she goes shopping with me. We go to the grocery store and what have you.
Okay. So you haven't noticed her skipping meals or picking at food or hiding food or anything like that?
Nothing like that, but I think it's important to understand that during COVID, her weight went way up and she was very self-conscious about that. And I've noticed her try to make more and more healthy, conscious decisions about she's eating more fruit, she's eating more vegetables, she's watching, more of the junk food. And so in a period of a year or two, her weight did come back down. She's in a normal range right now. I believe she's at 80%, but she went up over 95th percent during COVID. She came back down to where she's been since she was a little girl. I just feel like all of this is being, it's a bait and switch. Let's put our attention on this instead of the real issues.
All right. Well, I just wanted to see what you observed as far as her eating habits when she was with you. All right. Do you have any questions for him, Ms. Yoxel?
Not at this time.
Ms. Shoemaker?
No, Your Honor.
All right. And when is Bradley's graduation from high school? Is that coming up in May? Okay.
Yes, Your Honor. And
right.
Bradley gets 15 tickets. And I know the parties have been discussing, who gets, how to disperse the 15 tickets among, immediate family, extended family, and so on and so forth.
Well, there better not be a situation where either parent is not allowed to go, told that isn't going to fly. So,
Your Honor, not from our side. Absolutely not.
All right. Anything else? I mean, I think you all have kind of made your arguments already, so I don't think I need to hear an additional argument. All right, here are my concerns. One, and Ms. Shoemaker, I'm going to ask you to prepare the order.
Yes, Your Honor.
Mom was kind of put on notice about my concerns.
Okay, guys, I need you to perk up and watch what's happening here. Right above me, Miss Lee is about to lose her stuff as this order comes down. And the judge explains it really well. She was put on notice about this and her behavior didn't get better. So you can watch it happen right above my head. And don't worry, after this, we have another great emergency case with a pro se litigant.
At our last hearing, and doesn't seem to have been acting in such a way as I would have expected, knowing that a judge was telling me to, here's your warning kind of thing. You better watch out and act appropriately. So that causes me great concern. The letter from the nurse practitioner, the pediatrician, I mean, that had to have been initiated by mom. And that's just a little odd to me. I understand that both sides, counsel for both sides believe in their client and argue for their client and all that, and that's why we have a guardian. And I understand, Ms. Yoxel, you and your client are concerned about Ms. Taylor, but bottom line is the guardian has to form an opinion at some point in time, has to make a decision, and has to make recommendations. That's part of their job. And they're not always going to go along with, there isn't always a happy medium. There's a choice between one side or the other. And given what the children have represented to the guardian, how, Henry in particular, I'm concerned about their well-being, and I'm concerned about the conditions under which the children signed these affidavits of election, these recent ones. So I do find there's an emergency, and I'm going to suspend mom's visitation and pending the psychological evaluation and treatment. Mom can continue to have phone and video and text conversations with their children. And I will give dad final decision-making authority on medical decisions. So there's medication for children should never be conditioned upon one parent bringing the other parent to the other parent's house. I mean, that can't happen. That's certainly not in the best interest of the children. Now, Miss Taylor, how do the psych evals, how does that usually work? Do you submit 3 names and I pick one? I don't want mom submitting a name and I don't want dad submitting a name. So.
Yes, I am happy to do that. I mean, I know that there are 2 people I regularly use, and I'm happy to consider if council wants to email me who they would prefer. I'm happy to vet that. I could even reach out to Dr. Levitt if we wanted even her to pick. Maybe
Okay.
that would be appropriate.
Dr. Levitt is.
Carolyn Levitt was the parenting coordinator.
Okay.
I mean, I'd be fine with Dr. Davis picking. Those are all elite providers. So I don't care.
Who are the ones that you usually use?
We'll use Dr. Oppenheimer, who is the best of the best.
Okay. I mean, that is a name that is familiar to me.
Yeah. And she's we just hired her on a case. Yes, 3 days ago, I did on a custodial evaluation. But so what I can say about Dr. Oppenheimer, she had some surgery. She was not taking clients for a while. She is currently taking clients. However, she had to book us for the custody evaluation, which takes about 8 appointments. We're booked already, not until right after the Family Law Institute, and we're booked through mid-June. So I hate to, I mean,
I don't want to put it off.
Right. That's my only issue with her.
Okay.
Yeah.
I was just gonna say, if maybe Miss Shoemaker and I can submit a couple of names to Miss Taylor and then kind of go from there.
That would be fine. If you guys can agree to a name, I'm fine with it.
I would like to do someone that nobody's affiliated with, not Davis, not like someone afresh that can just really come in there and just do what they need to do, in my opinion, to make sure it's fair.
I'm fine with that.
I'm fine with that too.
Yeah.
Okay. All right, Ms. Shoemaker, will you please submit the order? Of course, copy Ms. Yoxel and Ms. Taylor on it.
Yes, Your
Yes,
Honor.
this time, Ms. Shoemaker, if you wouldn't mind sending it to me first to review before sending it to court.
Yes.
Okay. All right. And please know, this does not give me any pleasure in doing this. This is my absolute least favorite part of my job. I hate it. I absolutely hate it.
I'm sorry, but I am going to speak at this point.
You're not. You're not going to speak. You're not going to speak, or I will have to remove you. You have an attorney.
What I like to ask, Judge, just of some parameters. So my client will seek the psych eval, but when will she be able to be permitted to have visitation? Because again, like I said, there's so many events happening in the next few weeks that she's either already a part of or going to miss.
Well, I'm fine with her obviously going to graduation. If she's in public with them, I think that's okay. I could live with that, but I don't want the kids to be put in a position where there's potential for guilt tripping or pressure or anything like that. So I can amend that actually, if you'd like. If it's a public setting or a large family setting, I'm okay with that. It's not like I don't want her to see her kids. I just don't want them to be in a situation where they could potentially be pressured. Ms. Taylor, are you okay with that caveat?
It's that one-on-one situation that concerns me.
All right, so let's change it. It's the one-on-one.
Well, I mean, what in the home is what I'm saying.
In the home, yes. So no overnights at mom's home, but
yeah.
Well, let me ask you this. What about if mom and Jean want to go out for dinner with the kids one night a week or something? I mean, I don't want mom to not be seeing her kids. I just don't want there to be that alone pressure potential.
I'm okay with that. I don't want them to stop seeing her either. And I want I mean, the sooner the psych eval and treatment starts, the better.
Okay.
I guess that's, I guess, my next question. I'm sorry. So hard to get hearings. When,
We're pretty good about working people in. So
well, I think my request to get my client back to getting visitation is not an emergency. So
no, I disagree with that. If a mom hasn't been around her child for a period of time, and if she complies with everything I tell her to do, and now is in a position to get the child back, I see that as an emergency. I try to think of these things that if it were my kids, how would I feel? So
And I agree with that, Your Honor. I will be the first to bring it back. I want her in treatment. I want the treatment providers to get to talk to everyone that, that can, and let's get started on, healthy.
So the sooner the better. And I'm fine with mom having, going out somewhere with the kids for dinner with her husband or with kids' friends or neighbors. Family events are fine. Graduation is fine. It's just the no overnight visits at mom's house and no staying over for the time being. But mom still.
We need, because these parties don't ever agree on anything,
Right.
And that today is Friday. We need specifics. So can it be every Wednesday night that they can have dinner with mom?
Sure.
Is it Wednesday night?
Oh, that's the therapy day. That's a therapy day. So let's pick a different night.
Tuesday night, any night.
Any night. I don't care what night it is. Sure.
It's not in the order.
That's a very good point, Miss Yoxel. I agree.
Your Honor, I would just ask that any public visitation for that purpose is good, and family public family events. If the grandparents,
that's even better.
Yeah, are present. I just would say I don't want daytime visits at mom's home. I mean, you know what I'm saying? That's
right. Well, the kids are, no.
Public events.
Public dinner.
Large family gatherings are fine.
Outside of mom's home.
Outside of mom's home. And I think it's a good, are her mom's parents, do they live nearby or?
That Mr. Lee's parents. I think that's sort of.
I don't know how that would work. Do they get along? I don't know if that's a good idea. But what about mom and Jean and Ellis?
Yes.
Mom
They're very
Jean.
Close. Okay.
So I'd be fine with that. Just have mom and Jean and Ellis. Is there does he have another child, Jean? Just Ellis. All right. So that way she can see Ellis too. So do dinners out every Tuesday night, starting next Tuesday with mom, Jean and Ellis, and dad can drop off or pick up or something along those lines. So that Ansley's 14. Does Henry drive?
Not
No.
yet.
Not yet, Your Honor.
Okay.
Bradley drives back.
Bradley
So
drives?
can we just say mom picks up at dad's house and brings back so that they're just going
That's
out?
fine. That's fine. As long as Jean is with her, that's fine.
Okay. And then I'm being a pain in the butt and I'm very sorry. So Ellis only visits on the weekends. That's her parenting time. So could we coordinate a lunch or something during that weekend?
Your Honor, this is the hope is that this is temporary and that we get the
Of course. But still, I still would like Ansley to be able to see her sister. So I'm fine with doing a weekend lunch in addition to Tuesday night dinner.
Not every weekend, maybe once or twice.
Well, she wouldn't be with dad every weekend. It would be every other weekend.
Can we do every other Sunday, aligning with Ellis's visit from 12 to 2?
Sure. 12 to 2 every other Sunday to align with Ellis's visit.
And Your Honor, Ansley has ballet on Tuesday, so we make the
Thursday. Do it Thursday. Or if they do it after, what time is her therapy appointment?
Her therapy is on Wednesdays at 6.
Okay, that's going to interfere with dinner time. So what about Thursday? Do it on Thursdays.
Thursday she has ballet, I think.
Well, something's going to
What
have
about
to.
Monday?
Monday.
Monday nights. Okay.
Yeah.
Yeah, and also, what about temporary child support for my client? There's no child support, and I wouldn't ask, but for the fact that Miss Lee has not been contributing to uncovered medical expenses.
That's not true. That's not why we're here
That's-
today. And if this is supposed to be temporary, come on.
I'm not, hold on, Miss Yoxel. I'm not going to grant any temporary child support at this point. Miss Lee's going to have to pay for a psychological evaluation and any treatment, which is more important right now. Dad has the ability to take care of the children. So no to the temporary child support. And again, this is going to be a very temporary situation, at which point I would consider it to be an emergency to get everything back on track once the evaluation and treatment are completed.
Yes, Sharon.
Okay. All right. Are there any other, and they're still free to text, FaceTime, all of that other stuff is fine. Daily. Okay.
Thank you, Judge. I appreciate all that.
Okay.
Thank you, Judge.
You're welcome. Anything else?
And so it'll be obtain a forensic psych eval and comply with all treatment.
Any treatment that's recommended, and then bring it back to me with the evaluation. Why don't you bring, after she has the evaluation done and reported, bring it back to me so that I can see what the treatment, what it's looking like and what they say. And maybe we can address it or make some tweaks to this before the treatment is completed. You know, in other words, if they say she's going to need treatment for a long time, I don't want to keep holding, you know, so after you get the evaluation back, just report back to Mohini, let us know what the status is. Obviously if the parties could agree to, if something you think needs to be changed and they can agree to it, fine. And if not, we can reconvene at that time to see what, if anything, we can change. The plan is not to keep mom from her children. It's just to help calm things down right now, and to put them in a better position for going forward.
Okay.
And
And
so-
last request, can we just say that Ms. Shoemaker and I need to submit names by Monday, just because I don't want anyone, I'm not saying she would delay.
No,
Ms.
that's fine.
Very prompt and responsive, but I just to be on the safe side.
Well, and the other thing, guys, is you're going to have to call these providers and see what their waiting list is. Because if we're getting a good one, they're going to have a waiting list. So you just want to make sure you do that first, which may take
How about, let's do this. Get it to me if you can by Tuesday, the end of the day, Tuesday. That'll give you a little bit more time to try to reach some folks. And I'll try to sign it as soon as it comes in. Or figure it out as soon as I get it.
Mr. Judge, this is just because, you know, I've had this in my own cases. So she'll immediately start complying with treatment. Of course, we'll bring it back while that's happening, like hopefully.
Yeah, I don't want to wait till treatment is over to address this.
I think it will be ongoing, and I know that, yeah. And so then my only thing would be that it get released to me and the court.
Yes, the HIPAA release. Yes.
Yes.
Out of the order too. That's a good point.
I'm not going to share it with anyone else. And that way
I do not want the psych eval to go to dad. I don't want dad to be able to have that to use for any ammunition for anything. They don't.
Yana, what about counsel? Yana, because if it's going to the court, I think I'm entitled to get a copy of it.
I don't need a copy of it.
I don't.
I mean, I'm fine with there being language in the order that I can't, you know, share it with dad.
I mean, you're an officer of the court, so I would trust that you would abide by the court order. So as long as there's language in there that both counsel will be apprised of the report, but the contents, photographs, copies, anything will not be shared with that.
Or used in the trial.
Or used, correct. Or used by dad. I can rely on the information. So I don't want to carve me out from being able to use it if there's something in there that I think is important, but shall not be used by the opposing party during the course of the litigation. And copies shall not be made or disseminated, standard kind of non-disclosure language, except that the court gets to rely on the information.
We'll obviously provide that to you directly from me, but not to be filed, obviously. So
Correct.
Yeah.
Correct. Yep.
I guess I have a question. If opposing counsel can't use it, why, and can't give it to dad, why does opposing counsel need it?
Well, if it's going to the court, aren't both sides entitled to the information? I mean, I don't think.
Your Honor, yes, I would agree with the court that if it's going to the court and the court is considering it and making its decisions, I am entitled to a copy. And frankly, I think, and I'm kind of sitting here thinking about, what the court wants in the language of this order. But I also think that if, let's say that it's something that I need to refute if we go to trial, I think that and the court's going to consider it, I need to have the ability to refute it.
I think what you would need to do would be, I don't know, how would you,
let me ask you this, Judge. If you are willing to, if your position is that you're going to agree with the guardian's request, if I entered into a consent order, like saying that my client will go ahead and do this, would that, at that point, would it then be something that could be remain solely for the guardian, unless she needed to disseminate it to the judge for some reason, in the sense that either mom's not participating?
I see. So in other words, send it. So the proposal is, I'll give you a chance to respond, Ms. Shoemaker, is just release it to the guardian. If the guardian thinks it needs to be released to the court, then at that point it gets released to the attorneys and the court. Is that what you're suggesting, Ms. Shoemaker?
Similar to like a DFAX, like in-camera inspection, like you're only going to show me if necessary.
Your Honor, and I would object. I would object to that, and I would think that both sides were, because there might be stuff in the psychological evaluation. I think if the psychological evaluation comes back and says, "Hey, look, mom is perfectly fine," then of course Miss Yoxel is going to want to use it. Whereas if there's issues with mom, and let's say there's issues with mom, and the court is going to disregard it, then I have a right to refute that, or even bring in my own expert.
Well, why can't I do an ex parte review of this like I would for DFAX records?
Your Honor, yes, but then, if the court were to rely on any portion of the psychological evaluation, then I think that the court would be required to, at a minimum, release it to counsel, to the parties.
So I don't disagree with that. I'm sorry, I'm interrupting you. My opinion on that is I do very much want mom's information protected, because I think both for the best interest of the children, because that is a huge thing in her head, which I absolutely understand. And I think for her to get treatment that she's willing to engage in, she needs to know that's private. And so I would ask that, I think it could be redacted by the court. I mean, a diagnosis, but without maybe all of the things that like we would do for DFAX, right? And if we for even that medical records, we'll take out and just put the diagnosis. So I think that if we could do it to the court in camera, then have meet about it if necessary, and or the court redact and only share the diagnosis and the required treatment. I mean, I think before, on an ongoing basis, we're going to want her to keep in treatment even after this court is done, and therefore there would have to be some transparency between the parties as to treatment, like just, hey doc, is she doing it, kind of thing, not what's happening. That's my only suggestion.
Your Honor, maybe, and I'm going to kind of take a middle ground, and maybe what we do is we kind of kick the can down the road a little bit, because if diagnosis is an expert opinion, and if that diagnosis is then later going to be used on it in court, and I bring in my own expert to refute that diagnosis, and this is just a hypothetical, I'm not saying it's going to happen, but if I were to bring in my own expert to refute that hypothetical, then I would be entitled under the evidence statute to the documents that that expert that issued that diagnosis relied upon to issue that opinion. Maybe what we do is we get it done, and at this point, it's just released to the court, and maybe we reserve that issue of releasability for a later date. And maybe we kind of just get it done and then figure out how we deal with that later.
Well, this is a big can to kick down the road.
Yeah, and I appreciate mom's concerns about confidentiality, but I also have to represent my client.
I understand, but I don't know if I can order it be ex parte.
How about a fair thing to do would make both parties go through a psych eval, then everyone has access to everyone's craziness, and then no one can complain.
There's that. Maybe that's not a bad idea, actually.
And then no restrictions on who can look at what, and then everybody feels like they got their fair shake in that.
Patty, or I'm sorry, Ms. Shoemaker?
Yeah, I'm not necessarily objecting.
Okay, great. Then let's do that. Let's do that. That seems to be the simplest, cleanest, easiest thing to do. Both sides will undergo their own psychiatric evaluation.
Then, Your Honor, then both psychological evaluations come back to the court and to counsel.
Yep.
I still believe that there should be, the standard restrictions where,
they don't need to be disseminated or disclosed outside. They don't need to be filed in the court, in the record. Standard non-disclosure language other than the attorneys, the guardian, and the court.
I've seen it said that counsel cannot provide a copy to their client. They can review it in the office only.
Okay,
that's fine.
That works.
Your Honor, then I would go back to my earlier question about child support, since both parties now are paying for a psychological evaluation.
I'm still not going to do child support right now. Let's see what happens with this and see where we let's give it a couple of months and see where we are. And if we're going to make any long-term changes, we will address the issue of child support at that point.
Your Honor, can you admonish mom to start paying for the therapy is my request.
That was in my prior order, correct?
Yeah, she's been paying. She's going to pay for it. That's fine.
But she hasn't yet. So she needs to do that ASAP.
Okay.
And also, go ahead.
Can we also agree that whatever therapist we go with, psychologist, that's it'll be for both of them. We're not going to do one for this one and one for that one, and then it becomes many variables.
Right? I think it's very helpful, and it would also help cut down costs because they're communicating. The forensic stuff comes naturally.
If you guys are in agreement with that, it's fine with me.
I'm sorry. What was that last part?
She said it's easier and less expensive that way if they both use the same.
Oh, psychologist to do the psych eval.
As long as the psychologist doesn't think there's a conflict.
There's not.
Okay. Not. And I think that's better because the psychologist will administer the same test to both parties. Your Honor, and if the court's not going to, give us child support and each party's splitting the cost of the psych evals, my client's bearing the sole cost of the guardian ad litem. Can we at least split that?
He's not. No, he's not. He has a higher percentage. He makes a lot more money. My client hasn't been employed for several years, and now she's back this week. Thank goodness, working. Again, this is not.
I don't want to. Was there a request for child support in the emergent? That was a separate. That hasn't been raised because the guardian filed the motion. So I would prefer to not address child support today. Let's wait. I don't think this is going to be really long. Let's wait a couple months and see where we are. And then once we have the information from the report, we can evaluate it and we can address child support at that time. Now, there's one other issue. Ms. Yoxel, your client is putting messages in chats, taking Mother's Day from me. So let's make it, okay, let's make it, put in the order Mother's Day, that's a good point she raised, that she be able to do something with the entire family, not just like out for lunch, something together as a family. Same restrictions in place, but she will have Mother's Day.
Thank you, Judge. And there's money out on both sides. I'm not going into it. We'll deal with that another day. I'm going to send Miss Shoemaker. She's asked me several times, in all her fairness, for me to get her the specifics, and I'll get her that hopefully next week. But we'll deal with all of the money stuff. But I will make sure my client pays what she needs to pay for the therapy.
Thank you.
Can we ask that neither party shall discuss
With the children?
Yes.
That should be without, I shouldn't have to say that.
I know.
But if
It's in all the orders, it's in all the orders, but
we'll put it in this one too.
Thank you. Just as a current and present reminder.
Well, what did we think of that? What I want to hear, and don't go anywhere, folks, because we have another amazing hearing coming up. It's another emergency hearing. This one has a pro se litigant. I'm going to be honest, I haven't watched this whole one, so we're going to see it all together. Take this opportunity to subscribe to the channel. If you're not already subscribed, hit the like or dislike button, whichever works for you. That's totally fine. Give me 2 seconds to just switch this up with our other video here. And oh my God, this guy, you guys. Oh, you guys. This is another new judge. I bring you all the new judges. This is a strange case. We're going to have to figure it out together. However, we're going to start by, let me just read some of this, some of the chat here. Crazy, great, toxic. Yeah, absolutely. Another Mrs. Hubble. Honestly, we've seen this woman before. Still a million points to whoever finds the original case. It happened February 1st. I would assume that would be right around that time. Am I muted? Monica? Are you sure? This one got my attention because of the title. And then it got my attention because it looks like there is one participant who is an infomercial man. And
all right, good afternoon, everyone.
Okay,
here
sir.
For the
yes.
civil calendar of the 1:30
Sir.
p.m.
Sir, I'm not ready yet. Look at that look he's giving me. Sir. Mr. Freehoff. Okay? I wasn't done yet. This is a TRO hearing, folks. So let's see. But it's civil. We're going to figure it out together. Let's do it. Yeah, are they all hitting their buttons by accident and turning down the volume because they're so tired or what?
Emergency hearing in case number 2023-375-899. I see that Mr. Bishop is here on behalf of defendant. And I see Lewis Brown is also here. We have plaintiff Terrence Napier in attendance. Is Kenrick Johnson with us today?
Yes, I'm here.
Okay. Are you appearing as the iPhone is what it says?
Yes, sir.
Okay, I'm going to change your name for the judge's convenience so she can better understand who's speaking when you are talking. She may ask you to turn on your camera when we actually get to the hearing. All right, and then we have Lady Etiquette and Tia. Can anyone identify for me who these folks are?
A tenant.
I'm sorry?
You said Tia is a tenant.
Oh, she's a tenant. Okay. And Lady Etiquette is also a tenant? Oh,
No.
Lady Etiquette has disappeared. All right. So T is a tenant. All right. I just wanted to make sure I knew who all was on before we got underway. So the judge will be joining us any moment here. I do not see a court reporter. Mr. Bishop, was that your office trying to reach the chambers earlier about getting a court reporter?
It was, and I understand she's at a conference and we missed the 2 business day window, so we'll go as is.
Okay. All right then. Here comes the judge.
Good afternoon.
Good afternoon.
Okay.
Good afternoon, Your Honor.
Hello. So I have on for hearing today. Get my notepad so I can take notes. I have on for hearing today a request for a TRO in the matter of. I have so many emails open. It's a little frightening at this point. Terrence Napier and Kenrick Johnson versus Buckhead Preservation Trust, LLC, and Lewis Brown. I've reviewed the filings from the parties, and I am generally aware of the nature of the claims that have been brought by Terrence Napier and Kenrick Johnson. I'm also aware that part of the answer included some counterclaims that have been brought on behalf of the Buckhead Preservation Trust, and that the party seeking the TRO today are the defendants, the Buckhead Preservation Trust and Lewis Brown. Beyond that, I know there's some procedural information that I'm maybe not aware of that I expect you'll educate me on. But I am, with that information, ready to proceed when you are. Is that Mr. Bishop? Are you representing the trust and Mr. Brown?
It is, Your Honor, and I'd like to introduce to the court my associate, Jordana Oppenheim, who is a first-year lawyer shadowing.
Hello, Ms. Oppenheim. Welcome to the club. It's good to have you, and I'm happy for you to be here. Thank you, Mr. Bishop, for that introduction.
Thank you, Your Honor.
Okay, and who do I have representing Mr. Napier and Mr. Johnson?
We're gonna do pro se today.
Okay, so Mr. Napier, you're representing yourself, is that right?
Absolutely, yes.
Okay, and then Mr. Johnson is also representing himself, is that right?
Yes.
Okay, and who is Tia? There's another person on the call named Tia. Who is that?
She's a tenant who stays in unit number 6 at the property.
Okay. Okay. Okay, so thank you, Mr. Napier. And so I will, Mr. Bishop, it's your motion. So if you would like to go ahead, just to give everybody the lay of the land. Are you anticipating mostly argument? Are you anticipating the calling of witnesses? And if so, what is your estimate for how long you think you will need to present your evidence?
Well, thank you, Your Honor. I anticipate doing most of it through witness testimony. I expect I will need 20 minutes for Mr. Brown and maybe 10 or 15 apiece for Messrs. Napier and Johnson,
okay,
and maybe 5 to 10 for Tia, whom I've only just heard of.
Okay. Okay. And then we would potentially hear from any additional witnesses and evidence. Okay. Do you want to have any sort of opening statement, or do you just want to go ahead and start with your witnesses, sir?
I would like to open briefly, if it please Your Honor.
Okay, go ahead, sir.
Thank you, Your Honor. As you noted, this case has an interesting procedural posture. Messrs. Napier and Johnson sued Mr. Brown and an entity designated as Buckhead Preservation Trust, LLC, essentially on an alleged breach of contract claim. We answered timely and asserted counterclaims because the defect in plaintiff's pleading is that they are not a party to the contract at issue and don't have standing to assert enforcement of it. We'll get into some of that in the witness testimony. Briefly, Mr. Brown is the owner of the property located at 2896 North Fulton Drive. It's a 2986 North Fulton Drive, Atlanta. It's a 15-unit, used to be apartment complex that was turned into a condominium. Mr. Brown purchased it on behalf of the trust 20 years ago. And the counterclaims all have to do with Messrs. Napier and Johnson and whether they had any possessory or ownership interest in a particular unit, Unit 11, which was the only one Mr. Brown did not own. That unit was owned by Russell Martin, who passed away, and he was the party who was involved in the contract that may have, if it had been performed, sold the remaining units from the trust to him and his company. But Mr. Martin died, and the contract was not fully performed.
Okay, and so I'm glad that you mentioned that, because that was part that I wanted to make sure I had a little bit of a better understanding. Tell me the name of the individual who passed away.
Russell Martin.
Mr. Martin. So Mr. Martin owned Unit 11.
Correct.
And was, at the time of his death, either had entered into a contract or was negotiating the terms of a contract that would have, at least that's what I understand the allegations to be, that would have allowed him to purchase the entire building, so the remaining units, from Mr. Brown or from the Buckhead Preservation Trust. Is that right?
Correct, Your Honor.
Okay. And what was the status of that contract at the time that was it the contract had been entered into but had not been performed or closed as a real estate transaction, or was that it had not been finalized?
The contract had been signed but not performed.
Okay. Thank you. Go ahead, Mr. Bishop.
And thank you, Your Honor. That's the substance, I think, of the attorney argument. We would stand on our briefing. There are about 9 or 10 claims that all sound in declaratory judgment, TRO, trespass, nuisance, and rather than rehash all that, I think it would be best to call Mr. Brown as a witness and you receive his testimony on those issues.
Okay. Thank you, Mr. Bishop. You may call your first. Oh, wait, hang on. I apologize. Mr. Napier, do you wish to make a brief opening statement on these issues?
My opening statement is pretty direct. Mr. Martin passed. We were trying to figure out if that was even true, because we were business partners. I invested a lot of money into the property. I think that Lewis ill-informed his representation, and we'll sit here and prove that today. But yeah, it's pretty straightforward or whatever. I'm kind of offended by the accusations as far as what Lou was saying in his response with the attorney saying trespass and et cetera. I think is real disrespectful, and we probably shouldn't even be here today. We the ones who filed the lawsuit against him, and I don't know why he's taking this route, but we'll figure it out today.
Okay, thank you, Mr. Napier. Mr. Johnson, did you want to say anything, sir?
No, I don't need to say anything as of right now, because he said everything that I was going to say.
Okay, thank you, Mr. Johnson. Mr. Bishop, you may call your first witness.
All right, Mr. Brown, will you please raise your right hand so the court can see it? I'm going to swear you in. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Mr. Brown, would you please introduce yourself to the court?
Lewis Brown, trustee of Buckhead Preservation Trust.
And Mr. Brown, could you just give the court a little bit of background? When did the trust first purchase the property?
Oh my God. Okay. MB, you guys, you need to be on the listen for something coming up in about 1 minute. It is legitimately straight out of Austin Powers. I just about died laughing. I'm going to come back on screen just for this part, and then I'm going on. But I'm just prepping everybody. I need you to listen carefully to what comes out of somebody's mouth to the judge.
Oh, it was over 20 years ago. And when Russell Martin found the deal and brought it to me and wanted to partner with me on it.
So I see where you're going. I want to break that down some. You were business partner with Russell Brown.
Russell Martin.
I'm sorry, Russell Martin. That's right. And Mr. Martin brought the deal to you.
That was years ago. That was
Sure.
around 2001. And when once it was split up into condominium units, we departed ways, and basically his compensation was unit number 11.
Understood. I want to make sure that we do the legal documentation correctly. So, Your Honor, I'm happy to share my screen if that's easiest. I'm about to be discussing an exhibit that was attached to our TRO for Mr. Brown to verify it. Is it Your Honor's preference that we share screen to talk about exhibits?
Yes, that's fine.
Okay. Mr. Brown, I'm going to be showing you an exhibit here. Please let me know if you can see it.
I see something on the screen.
Yeah, it's very tiny,
it.
Mr. Bishop. So you definitely are going to want to zoom in for some of us with older eyes, right, Mr. Brown?
Yeah, baby.
Is that any better?
Well, it's on a page that doesn't have a lot of text, so.
Okay, all right. Let me see if I can pull it onto it. I've got two screens here, Your Honor. Let me see if this other screen's a little bit better. Try it here. All right, how's this one?
That's much better.
Okay. All right, Mr. Brown, are you looking at what's been labeled Exhibit 2?
I can, yes.
Okay, and as I scroll down, do you see a document entitled Limited Warranty Deed?
I do.
And I'm just going to read the first paragraph to you. This indenture made of March 12, 2021, or excuse me, 2001 between Inman Park Properties as grantor and L.D. Brown as trustee of Buckhead Preservation Trust. Is this the deed of the purchase of the property you referenced over 20 years ago?
It is.
And as I scroll down, is that the correct signature of you as a witness and the grantor here, Mr. Notrica?
I was not a witness to that. That is not my initials, but yes, Jeff Notrica is the one we purchased it from.
All right. And have you seen this document before in connection with your temporary restraining order pleadings?
I have.
And it was attached to your motion for a TRO?
That's correct.
Okay. And I'm just scrolling down here to the legal description. Is this, as you can see it, a correct description of the property which was sold to you, the condominium complex?
It looks correct, yes.
Okay. Thank you, Mr. Brown. I'm going to stop sharing my screen since we've established that that's a true and correct copy of the limited warranty deed attached to your motion as Exhibit 2. Have you ever, other than Unit 11, liquidated or sold any of your interest in the property?
No.
You told me about Mr. Martin walking away with Unit 11 as part of sort of y'all parting ways in your business partnership. Did you ever approach Mr. Martin, or did he ever approach you about purchasing the remaining units?
Yes.
Can you tell us about that, please?
So basically, it became a Mexican standoff. Essentially, we would have residents in other units and he would intimidate them and force them out. And so it was pretty much you buy us out or we buy you out. And in February of 2020, we came to an agreement that he would buy our remaining 14 units. However, he did not perform on that agreement.
Thank you, sir. I appreciate that. And maybe to avoid some of the back and forth with the screen share, maybe I can just ask you, are you familiar with Exhibit A that we attached to your counterclaim?
I don't know what Exhibit A is.
Okay, I'll show it to you then and see if that can help. Can you see the screen share that I have now, Mr.
I can.
Brown? Okay, so you're looking at something denominated Exhibit A. As I scroll down, I just want to ask you if you've seen this document before.
Yes.
Okay, is this the purchase and sale agreement to sell the other units to Mr. Mark?
It is.
Now I want to scroll down with you to the signature page. At the bottom of page 7, do you recognize these signatures?
Yes, I do.
Whose signatures are they?
Russell Martin III and my name as trustee.
And Mr. Martin's on the left?
Yes.
And you're on the right?
Correct.
And is this a true and correct copy of the purchase and sale agreement that you two entered?
It is.
And this is what you provided my office to file with this lawsuit, correct?
That's correct.
I noticed, well, let me ask you, were there any other signatories to this agreement?
Not at all.
So Mr. Napier is not signed on behalf of Mr. Martin or Venture Partners.
No.
And Mr. Johnson isn't signed on behalf of Mr. Martin or Venture Partners.
No.
Had you even heard of Mr. Napier or Mr. Johnson when you entered this contract with Mr. Martin?
Not at all.
I'm going to stop the screen share now. It cut out on me. Are you still there?
Yes.
I'm here.
Okay, great. I'm going to shift around here to another exhibit, which was tendered by the plaintiffs last night at 7:35 p.m. Mr. Brown, have you seen this purchase and sale agreement before?
When you pointed it out to me this morning, yes.
And so I want to go down to the same signature page with you. Page 7, does this appear to have Mr. Martin and your signatures on it?
It does.
Does it appear to have any additional signatures?
It does.
And what additional signature does it have?
I believe it's Kenrick Johnson.
Had you ever seen this before today?
No.
Do you know why there's a version with Mr. Johnson's name on it?
It makes no sense to me because the night that Russell Martin and I met over Chinese dinner and formulated this agreement, there was 2 copies, one for him and one for me, and we executed 2 copies, and he took away one and I took away the other one. And to my knowledge, there was no one else involved in that agreement. He and I sat over dinner and we worked out the details of the deal, and he never called anyone else. He never asked anyone else's permission. So no, I don't know of anyone else's involvement.
Understood. And I just want to go back real quick with you to the signature page on page 7 of Exhibit A. Looking at number 2 under the buyer side, there's no printed type in there for the buyer's name and address, right?
No.
Okay. So if we switch, and it was Exhibit A, which I just put back up on the screen, is that how it looked the night you signed it at the Chinese restaurant?
Correct.
Okay. So if we go back to plaintiff's exhibit under 2, it looks like someone has kind of typed back into the document Mr. Johnson's address and information. Is that right?
That's what it looks like to me.
So that then would not have been the original document that you signed?
No.
Thank you, sir. I'm going to stop the screen share for now and return to regular examination. Are you aware? Let me ask one more question about the PSA. That purchase and sale agreement did not grant immediate ownership, correct?
No.
In fact, it had to satisfy a payment of $2.3 million some odd dollars before ownership transferred, correct?
That is correct.
And you never transferred ownership outside of after you received that limited warranty deed that we looked at earlier, right?
No.
Okay. Do you know whether Mr. Martin ever entered a lease agreement for Unit 11?
No, he never, he lived there. So no, he didn't enter into a lease agreement with anyone else.
So let's come forward in the timeline some. We talked about this agreement that was entered in February of 2021. Did Mr. Martin pass away at any point in time?
So to my knowledge, I was called the day after he passed away by a friend, a mutual friend who knew me and knew him. And he told me that he had passed away. So I said, what? I was in shock because I didn't even know he was in the hospital. I knew he had some health problems, but I didn't know he was in the hospital. And so I said, no, I don't know about that. I just happened to be in Buckhead at the time that I got the call at the Home Depot there. And so I went over to the building right away, and there was no one there.
And do you remember what day or month this was?
Well, it was definitely December. It was December 27th, I think, something around that time. And I was actually looking at the closeout Christmas decorations at Home Depot when I got the call. So that's how I remember that. But I don't remember the exact day. I think it was a Wednesday, but I'm not sure.
And when you say December, is that of 2021 or 2022?
2022.
2023. All right. Have you ever been, who contacted you about Mr. Martin's death?
Pennington Green.
And who is that?
Pennington was someone that Russell knew, and he was like a mediator. He became very interested in what.
I'm sorry, but Pennington Green is like the fakest name ever. That sounds like somebody who's gonna rip you off, doesn't it? Hello, my name is Pennington Green. Lovely to make your acquaintance. No, I will take all your money, please. That would be great. No, Pennington Green. You've never heard of us, or? Sorry, I had to say that. Also, does he not look like he's from an infomercial, the guy in the blue shirt? The kitty has cat things to do. She does.
What we were doing and how we were doing it. He had an interest in buying the building with Russell Martin at one point. When that didn't work out, he just called me for real estate advice from time to time. And he would tell me the different projects he was working on and just maintained a relationship with me.
Did you ever speak to any of Mr. Martin's family about his passing?
I did. Once I knew about it, Pennington got me in touch with some of the folks that were his family in Savannah. And so I ended up talking with his sister, and she basically was trying to navigate whether they were going to bring his body back there or whether they were going to bury it here. He had a very estranged relationship with his family, with his two sisters, and his mother. His mother disowned him, and his two sisters had not had contact with him for many years. So they were all like, we kind of hands off about the whole thing. And she got a copy of his will, and she was appointed in the will as his executrix, and he had left his belongings to her son. So she had an interest in it. And
Is that a real word? Executrix? Oh my God. This case is so good already. Executrix? Oh my gosh. How do you even know that? Have you ever heard that in all the time that you've ever been listening to court cases? I haven't. Oh my gosh.
And eventually she traveled from Savannah to meet me there at the building.
Okay, so you went to the building then with Mr. Martin's sister?
Correct.
And was that the first time you've been to the building since Mr. Martin passed?
No.
Okay. Can you tell me about the first time you went and then your visit?
I know what it is, guys, and I've never heard about it before. You guys telling me that you can. Heather, executor that's on the corner. My next album will be named that, Valentino. My first executrix. I heard dominatrix. Whoopsies. Me too. The tricks at the end, right? Also, Lady Etiquette. Lady Etiquette should be the fairy of Zoom who goes around and gives good behavior to the people on Zoom if the judges do their chores. But if the judges are naughty, then the people in front of them, they might go potty.
With the sister?
Well, the first time I went was that, like I said, that day that I heard that he had passed away. And then I checked out the building. There were some units that were open. Most of the units were locked. And so knowing that we owned the 14 units, I ordered that the locks be changed. I talked with his sister. She was worried, who might have the keys to the building. I was worried who might have the keys to the building. So she asked me to change his lock as well. So we changed the locks on all 15 units.
And did those locks remain changed?
No, we went back about a week later and found that 3 of the units' doors had been kicked in. And so I had Donnie, my maintenance supervisor, go back over there and secure those 3 units. Then we went back and found that all of the locks had been changed on the entire building.
Were you able to, well, first of all, let me ask you, how much did it cost to get these locks changed?
$950 was the bill plus Donnie's time, which was a separate number.
And all that down the drain after the locks were drilled out, right?
Correct.
Were you able to investigate and come to a conclusion about how or why the locks had been drilled out?
Well, I was in shock, and the only number I had was, so Russell Martin had passed away, but he had someone, a friend, who took him over to the hospital, and Russell appointed him as his next in line emergency number. And so his name is Alex. And so Alex contacted me, and then he through my connections with the sister, we all got together and we met over at the building that same day that she came in from Savannah. He brought all of Russell's personal belongings from the hospital, and including his phone. His phone did not have a password or passcode on it, so we were able to see numbers on there. And what we had been told is that Ken, not Kenrick, but Ken was the guy who was like his maintenance guy and would sweep the water off the building and things like that, sweep the water off the roof that was leaking. And so he was doing maintenance stuff there. So I contacted him, hoping that we would be able to work together and perhaps he could do some work for me. So he led me to believe that that's what we were doing for a while.
All right, so I want to break this down. I promised the court I'd be judicious with your time, so I want to hit some more high points and conclude your testimony. Tell me about the first time you reached contact with Mr. Johnson.
He asked me, where's Russell? And I had his sister, being concerned about things, did not want me to say, so I didn't say. I just said, I don't know.
And what happened after that conversation?
What happened after that? Well, we talked several times about different things. I wanted to get my people on the property. I had my worker there. Obviously, I'd had Donnie already change the locks, and then we found that the locks had been changed again. So I needed to get my people on the property to do the valuations of the electricity, the plumbing, the roofing, the painting, everything that needed to be done there, which, you know, was significant in some units. And, you know, so what happened was we were blocked, and basically Donnie came over there and he was essentially escorted off of the property. And then I had my plumber go over there and he was escorted by Kenrick out off the property. And then I had a plumber go. So I had an electrician, plumber, roofer, and my carpenter slash property maintenance supervisor over there. And all of them were basically told to go away and were forced off of the property, you know, from an intimidation standpoint. So
I'm sorry, I didn't mean to cut you off.
Yeah, go ahead.
Well, I was going to ask, who was it that escorted them off the property? Who thought that they had control over the property?
Kenrick Johnson.
Okay.
Kenrick would not give me his last name, and then one time Kenrick got me on the phone with Terrence, and Terrence would not give me his last name either.
Did you find their last names out for the first time when they sued you?
Yes.
Had you ever given Kenrick Johnson the authority to control ingress and egress from the property?
Not at all.
Had you ever given Mr. Napier authority to control ingress and egress from the property?
Not at all.
Had you ever leased a unit to Mr. Johnson?
Not at all.
Had you ever leased a unit to Mr. Napier?
No.
To your knowledge, did Mr. Martin?
No.
To either of them?
No.
You said your crews were escorted off and intimidated. Would they go back now? Like, could you get someone out there to do the work?
If we had control of the entire building, they would go back. But if we did not, they would not go back.
And is this because they're concerned for their safety?
Yes.
And then, so let me ask this question. If the locks are drilled out, was there
excuse me. Can I address?
Mr. Johnson, do you have an objection?
Yes, about the concern of the safety issue, because when he came here and he broke into my Unit 11,
well,
my
hang
guns
on, Mr. Johnson, let me interrupt you for just
I'm
a second. So, no, that's okay. So you will have an opportunity to ask Mr. Brown questions and to challenge the testimony that he's giving when it's your opportunity. But right now it is Mr. Bishop's opportunity to ask Mr. Brown questions. So the only time that you would interject in that situation would be if you had an objection to the nature of the question or something about that. But if it's substantive, then it would be you should wait your turn and then you would be able to ask Mr. Brown questions or challenge the testimony that he's just given. So with that guidance a little bit, do you have an objection or do you just want to disagree or challenge the testimony that he's giving?
I disagree.
Okay. Well, then I'm going to ask you, Mr. Johnson, if you'll wait just a few minutes and then you will have a chance to ask questions. Okay.
Okay.
Thank you, sir. Go ahead, Mr. Bishop.
Thank you very much, Your Honor. Let's see, Mr. Brown, coming back to the ability to do work on the property, are there external gates?
There's 3 external gates that block the building from access from the outside.
And have you been able to access those gates or get into them since Mr. Johnson took up residence?
Not since he changed the locks. Basically, except for one time when his niece let me and Mr. Martin's sister's attorney come into the building. She did not know that she was not supposed to. She said that after she called him and he said, you weren't supposed to let them come on to the property. We were already on the property. We had already toured a number of the units and including unit number 11, where we found that all of his antiques and all of his business papers and everything had been removed from his unit. So that's when they basically said, you've been sued. And I said, I don't know anything about it. And they gave me a piece of paper, a 1-pager that without any proper service or anything like that. So that's the first time I found out about anything related to being sued.
I appreciate that. Thank you. I want to break down something that you said. Why would you have been told you weren't allowed on the property?
Yeah. I'd like to know that myself, because basically there was absolutely no agreement on my part to let them take over the property. And I know Russell Martin, and I know that Russell Martin did not give them access to that entire building or any kind of agreement to his own unit where his grandmother's sofa was and all of the antiques that he had in there. He definitely was protective of his stuff, and no one was supposed to be in his unit.
And so did I hear you correctly that you weren't allowed on the property? Mr. Johnson's the only person on the property, but yet Mr. Martin, the deceased's personal effects and antiques were going missing?
Yes, they were gone by the time I got there with Melinda's attorney. That's when I found out that they were missing.
Okay. We've talked about the broken locks, we talked about changed locks, we talked about items going missing. have any of the other units been broken into?
Oh, yes, all of them.
Okay. And were there anything missing from those, or were they
Yes.
using utilities? Okay, tell me what was
Well,
missing.
absolutely. So the utilities were on in unit number 12, which is one of the units that we own. And they had strung cords from unit 12 to unit 11. And basically they were using a propane heater in the unit because there was no electricity on in unit number 11.
All right. I think we've about covered it all, Mr. Brown. I want to make sure that I hit a couple more things with you. You took some pictures at the property showing water damage. Is that water damage still ongoing?
It is. It is. That building is under siege, basically, and it desperately needs a roof. And I have roofers, but like I said, I can't get the roofing job done.
And have you been able to lease or sell any of the units since this whole saga began?
Oh, not at all. I mean, no way. If you can't get people in to even look at the building, even to do work, there's no way that you can lease a building.
And do you have an idea? Well, let me ask you, you see the person who joined on the call, Tia, who plaintiffs represented as a tenant. Do you know who that is?
Never heard of her.
Did you lease unit 6 to Tia?
No, I did not.
So Tia would be another squatter subject to ejectment, right?
Correct.
Can you give us an idea in terms of lost time, value of money, what could be going on if you were able to rent these units, had access to them?
Well, these units would rent from anywhere from $1,500 to $2,500 per month. There's 12 2-bedrooms and 3 1-bedrooms. Or you might say 11 2-bedrooms, not counting Mr. Martin's unit. So there's 11 2-bedrooms and 3 1-bedrooms that we could lease if we were able to get the work done and get them rented. There are some units that were rentable in my estimation based on my inspection of them in January. We did make pictures of those and what have you. And so we were prepared to immediately lease those in January had we not run into this problem.
Two more questions for you. One, what is your understanding of Mr. Martin's estate? Could he sell unit 11 right now or otherwise get rid of it? So is it still tied up in probate?
It would need to be probated because it's in his name exclusively. And he and his estate own significant homeowners association dues to the homeowners association.
And so and you talk about the homeowner association, you mean under the condominium organization's rules, right?
Correct.
And under those rules, no unit owner could exclude another owner from the property or the common areas, could they?
Correct.
And so I guess I got to ask you, with the locks changed, can't get in, the looting, things going missing, violation of the condo rules, you can't get even to the common areas. What remedy do you have if the court doesn't grant our motion today?
I have none.
Thank you, Mr. Brown. That's all the questions I have for you right now. Let me tell you, I think the judge will advise you that the plaintiffs may be able to ask you questions, and then I'll redirect you to close out your testimony.
Fine.
That's correct. Mr. Napier, do you have questions for Mr. Brown?
Yes, I have a few questions. Thank you, Your Honor. Mr. Brown, you admitted that you and Russell parted business ways back in 2020?
No, back in 2001.
No, y'all joined business in 2001.
Yeah.
He brought you to a property. You guys made an agreement. In that agreement, you guys ended and decided to go separate ways in 2020.
No.
Okay, that's what you testified to.
No, I didn't.
You said y'all split up. Y'all decided to go
hang on. Let's not talk over each other. I think, Mr. Brown, you had answered the question and Mr. Napier was trying to clarify what his question was or refresh your memory about what you'd said a moment ago. So let him do that. And if you guys will both try really hard to not talk over each other so I can hear what everybody says. Go ahead, Mr. Napier.
Okay, I'm sorry, Your Honor. you testified that you and Russell, after you had an agreement back in 2001, you decided 20 years later to separate because y'all had a Mexican standoff going on. Remember?
No, that's not what I said. To correct the record, it was 2000. As soon as he got his unit, that was the settlement. So we parted ways 20 years ago. And over the years, when we've rented out units, which we have a history of renting out units there under our account, not under his, we were continuing business under our ownership of the building.
So you guys were in business together in 2/12/2020?
No.
Your Honor, I've tried to give him some leeway as pro se, but I would object as asked and answered.
Sustained. I think you can go ahead.
Okay, I'm sorry.
You can move on.
Okay. Well, the agreement that your lawyer presented showed a purchase and sale agreement dated 2/12/2020 with your signature and Russell's signature. Did you see that?
Yes. Yes.
So under that agreement, you agreed to let Russell take over Unit 11.
No, under that agreement, he was going to purchase all the other 14 units.
Exactly. Do you have anything showing that he was in default of paying on this particular contract?
Oh, absolutely. When he didn't perform on the contract, it was 9-month contract and he didn't perform.
Okay, so you're a businessman, I'm assuming. You would have to have something that you sent in the mail or something to show that he was in default of this contract, right? If he wasn't paying you, you would acknowledge it in writing, wouldn't you?
No.
We would object to the extent it calls for a legal conclusion.
I'm just saying.
Mr. Napier, there's an objection. I'm the one who decides if there is a valid objection or not. So let's all not have any conversations with one another. Tell me again, Mr. Bishop, what is the nature of your objection?
I'll just withdraw, Your Honor.
Okay. Go ahead, Mr. Napier.
Okay. Well, in this purchase agreement, I heard him make an accusation that Mr. Johnson's name was added to the purchase agreement. He also acknowledged that Mr. Russell at some point was confrontational with other tenants that they had. But he knew Mr. Russell so well that he knew Russell's other business affairs. My question to you, Mr. Brown, are you familiar with Teague Hunter of Hunter Hotels?
Not until you brought his name to the conversation when you and I were on the phone together with Kenrick Johnson. I've never heard of Teague Hunter before that. If I have, I didn't recall it.
Okay. Teague Hunter is the CEO of Hunter Hotels with Marriott. He builds Marriott hotels and all hotels all over the world. My thing, we submitted an exhibit with a check from Teague Hunter to Venture Partners, ATL LLC. Do you know who is business partners in Venture Partners LLC?
Your Honor, we would object as for lack of foundation and hearsay.
Sustained. So, Mr. Napier, we want to try and focus your presentation on things that you can ask Mr. Brown if he has knowledge about them.
Okay.
But what we try to avoid doing is offering testimony about what other people said.
Okay.
If you have documentation or a different witness, we can try and approach it that way. Go ahead.
Okay, I'm sorry. I don't know how to share the screen or whatnot. I'm old. But it's a check that was submitted from Teague Hunter.
Is that, Mr. Napier, is that part of the documentation that
Yes,
you
ma'am.
attached to your response motion?
Yes, ma'am. It's a $60,000 check that's in attached. Check
Okay.
number 187.
Okay. So if you want to ask Mr. Brown about that check, you can. But if his answer is, which I think he may have already given, that he's not familiar with that check and doesn't know anything about it, then that's sort of the end of that inquiry. You could ask other people about it.
No, I want to ask Mr. Brown again.
Okay.
Mr. Brown, are you not aware of the Venture Partners ATL check from Teague Hunter for $60,000?
Not until this morning.
Okay. Now that goes to show we do have a legitimate check, and we have Teague who's willing, he's going to testify to this matter. Nobody's squatting, nobody's bums. You don't know who Russell Martin's business partners were. You testified, you know everything about Russell. Hold on. But you don't know who Teague Hunter is, who writes $60,000 and $100,000 checks to Russell to pay the taxes on a building through Venture Partners ATL LLC. Have you paid taxes on that building in the past 2 years?
Yes, I have.
Well, and Your Honor, we would just object to admission of the check. It is an unverified piece of hearsay evidence, and it did not comply with 911 7.1's redaction requirements for financial documents. So we'd ask the court to strike it from the record.
Okay. So I'm going to make it real easy. If I were to admit the document into evidence for Mr. Napier and Mr. Johnson's benefit, it would need to be redacted of any of the account and routing information at the bottom to avoid risk and concern of identity theft and other types of issues. That's number one. Number two, though, is that I've not heard anyone identify that document as being what it purports to be. And so it is not appropriately admitted as of yet. So for now, it is not part of the record. So.
Okay, Your Honor. Mr. Brown, are you a partner in Venture Partners ATL LLC?
Not at all.
Are you aware that the taxes for the past year and a half was paid and receipted to Venture Partners ATL LLC?
What I saw in your filing this morning.
I'm not filing. I'm just asking you, are you aware?
Your Honor, I would object that this is asked and answered.
I feel like if you've asked a question, then you should let Mr. Brown try to answer the question. And then if it's not responsive, then you can say that it's not responsive and the court shouldn't consider the answer. But for right now, you asked him if he was aware that some entity had paid the taxes. Did you say Investa?
Venture Partners, we have receipts that we pay Investa to do the taxes for.
Okay, Venture Partners, you asked Mr. Brown if he was
hold on. One moment, y'all. How do I look? Okay. Sorry to interrupt. When you're talking about if it's a real check or not, at least in Canada, I worked at a bank. That was my first job, Cha. We should write that one down. But when I worked at the bank, what I learned was that what's important on a check is the encoding, so the numbers at the bottom, and the signature. Much other than that doesn't matter. So I saw checks written on napkins, on paper, on anything you could imagine, and you accept those as a check as long as the signature matches. It's fine, and the account number is proper. Now, here's the thing. In the States, banking is very different. So you guys have like a lot of banks. You can own a bank. That's like, you can do that. You can't do that in Canada. It's very regulated here. So we have like 7 big banks. We used to have 5 big banks. Now we have 7 big banks. And basically all of those, like I worked for one of the big 5 banks. And as a Canadian, they could list them all off here by their acronyms very quickly. But so what that means is that the system is very robust for dealing with checks and stuff within the country, all pretty much connected. Whereas in the States, when you write a check, let's say you write a check and the amount of clearing it takes to get back to the right financial institution and properly clear is a lot more of a risk than in Canada. And yet still we don't use checks even near the same amount. But also in Canada, big checks, first of all, you spell it differently, and I can't get over it. We spell CHEQUE. That's how you spell check. And in Canada, you don't pay taxes on lottery winnings. So that. But yeah, that's really pretty much it. When I worked at the bank, so a money order or a bank draft, sorry, I'll just finish this tangent. Money order or a bank draft is Well, it's sad you think that, Tupac, but go ahead and check out British Columbia, which is where I'm from, and we have some of the most secretive and business friendly banking and finance laws in the world. We are a safe haven for numbered businesses in BC specifically. I I have experience dealing with money laundering and many different business types that I've worked in. But anyways, let's continue.
Aware that they had paid the taxes on that property. Go ahead, Mr. Brown, if you can answer.
So we paid 52,000 something. I submitted that information to Tyler. That was for part of 2021 taxes, all of 2022 taxes. So no, Venture Partners, nor Teague Hunter, nor Mr. Napier, nor Mr. Johnson, no one paid 2022 taxes except for me.
Also, on December 27th, as you claim, you were just mysteriously hanging out at Home Depot around the corner from the building, and someone called you Mr. Pennington.
I don't think it was mysterious at all.
But that day he called you was the day. Yeah, it's funny. We love Russell. We don't think it's funny that he's dead. This is kind of a serious matter, but it's funny. So it could be funny to you. Pennington Green contacted you that day and told you that Mr. Martin was deceased, and you came the same day.
Yeah,
is that true?
That is absolutely true.
Did you see Kenrick Johnson there that day?
No one was there that day.
Who gave you permission to go into Unit 11?
I talked with Russell Martin's sister, and she's the one that gave me permission.
His sister gave you permission to go into a unit. She had no authority.
Hang on, Mr. Napier. That's a legal argument, right? You can ask him hang on. You can ask him what authority did you think his sister had, but you simply stating she had no authority, that's a legal argument. You need to ask your witness factual questions first so that I can hear the evidence, okay?
Okay, Your Honor. Sorry.
That's okay. Go ahead.
What made you believe that his sister, who was estranged, could give you permission to enter into that apartment?
Because of the will. The will named her as the executives of his estate.
So, if you all had access to Russell's property, you guys would have had a key also, right?
She had all of his belongings. Remember that we met at the property. We met at the property with Alex, and Alex brought all of his belongings, including his keys and his phone and his personal clothing, those kind of things, his wallet, etc.
So you guys used used Russell's key to get in Unit 11?
Yes.
You go into Unit 11, you have a key. Why did you guys change the locks?
Because she asked me to. She said, I don't know who else might have the key. And so she had me, along with all the other locks, change the locks.
How many times were you on that property in the past 2 years since 2020?
No, several times. Basically, sometimes I would come there. Russell was not there. Generally, I would text him.
How would you describe you and Russell's relationship?
Strained.
Strained? Okay. So you're not against saying that Russell had his own company and business that you were unaware of?
I agree.
Okay. So instead of, let's say, saying that people are squatters or trespassers or ruining things, you just don't know.
I do know.
I
know your name is not on public record as an owner of that unit. That I know for sure.
You can debate. I heard about your debates in front. That's fine. What I'm saying is that you don't know what business affair Russell had going on outside of you because you guys were estranged. That's a respectable statement, don't you think?
Your Honor, I
Well,
would just object as
I'm
asking.
going to
answer.
save you the trouble, you've made your point, Mr. Bishop, Mr. Napier. Mr. Brown didn't know the ins and outs, or have a whole lot of visibility into Mr. Martin's business dealings. I don't have a problem accepting that. So if you've made your point, you can move on to something else.
Okay, well, since you don't know, and you and Russell were estranged, what made you believe that the people that were there were squatters and looters? How did you come to that conclusion?
Because I witnessed that a lot of things that were there that were owned by us were gone. The air conditioning units that had been removed from the right-hand building that were on the ground on the pad were perfectly good compressor units, outdoor compressor units that, along with all of the sinks and the pedestals and the other items, were there. And when I noticed them gone, that's when I considered it to be theft and looting. And along with seeing that all of his personal belongings had been removed from the unit and knowing that his sister did not take them, I definitely consider it to be that, along with things that were in other units that were not owned by Russell at all, and those being missing. Yes, I consider that theft and looting and stealing.
Okay, well, let me tell you about theft, looting, and stealing. Kendrick Johnson's relationship with Russell, he's there every day, which is going to be proven with our private investigator to show forensics of his location for the past several years being there. But if you didn't have access to some of the other units which are used as storage, how do you know that those items that you're saying are not still on the property? Did you ask? Did you ask Ken, the other Ken?
When the answer is, when I arrived there with his sister's attorney and he and I looked in those units, those things were not there. And we got to see enough of the building to know that they were not, mysteriously stored someplace in the building. They were not there.
But you have access to every unit with the lock on the door.
Yeah, we were able to see in or get into each unit.
Wow. Okay. That's just, it's not conclusive, but that, okay. So the units that were outside and the sinks and stuff that were stored, that you submitted pictures of in the exhibits, could that have possibly been trash?
No, not at all.
So since
Russell had told me, and here's the reason I believe so, because Russell had told me that he had moved those off of the roof in order for the roof to be repaired. So they were in good shape, as are the other ones that are on the other building that are still there. And they were purchased at the same time. And they were installed at the same time. So I have every reason to believe they were in good shape. You don't have 6 air conditioning units all go out at the same time and be trash.
Okay, let me ask you this. What name brand were their units?
I don't know.
Do you know who paid for the units?
Well, back then, when they were originally installed, I paid for them.
If they were
about that one.
They were new. Some of them were never used, right? They couldn't go on the roof because the roof is messed up. I'm asking you, do you know the type of units? Do you know? You don't know. Well,
I have a picture of them. That's all I have.
That's a picture. So were you there the day they were purchased?
No. I believe I was. If you're telling me that they're new, no, I was not there when they were purchased.
Did you ask Ken, the maintenance guy, who you had repertoire with? Did you ask him what happened to the units?
I did.
What did he say?
He said, none of your business.
Why would he say that to you?
I don't know.
If you were Russell's friend?
I'm gonna instruct you not to answer that question. That question calls for speculation. You're asking him to speculate about why somebody else did something. And so maybe rephrase your question.
Okay, Your Honor. All I want to submit to the courts is that Russell, obviously, I don't know Mr. Brown from a can of paint. I've heard his name when these issues came up. I go back and forth from Las Vegas. I know what I paid Russell or Mr. Martin because my relationship with Ken goes extensive years. And I was going down to that property because I was interested in buying a property across the street called Copper Cove until the developers across the street purchased it. They presented me with certain paperwork that led me to invest a large sum.
Mr. Napier, forgive me for interrupting you, but you're testifying right now, which you're free to do when it is your turn to do that. But if what you're saying, if you want to ask Mr. Brown about it, now is the chance for you to ask Mr. Brown about those things. But if you want to testify and tell me about those things, then you need to wait until it's your turn to testify.
Okay. Sorry again, y'all.
That's okay. I mean, there's a language that goes with being in court that someone who's not a lawyer doesn't necessarily know. And I'm trying to work with you on that issue.
Right. And also we're in pursuit. We're trying to find the right person to represent us. We don't want to just hire anybody, but since this is an emergency, we're responding as an emergency.
Okay.
So I guess what I want to submit to the courts is that I just think that.
Well, Mr. Napier, hang on. Forgive me for interrupting you, but now it sounds like you're making an argument about what relief you want. And I understand. I want to hear all of those things. Okay. But right now, procedurally, do you have any questions for Mr. Brown? If you don't have any questions for Mr. Brown, then it will be Mr. Bishop's turn to call another witness, and we will continue to move through the process of evidence.
Okay, my question is, what reason would you have to call people who you don't know squatters, looters, and trespassers? Criminals.
I would just object to that, Your Honor, as it calls for a legal conclusion.
I'm going to overrule the objection. I don't know about the criminals part, but it does sound like there's some cross chatter about characterizing the individuals that were allegedly living in the house as squatters. And it's fair, I think, to ask Mr. Brown why he referred to them in that manner. Go ahead, Mr. Brown.
Because I know that this gentleman was not occupying Russell Martin's unit. I know that Russell Martin was occupying Russell Martin's unit. And when I see other people in there that were not given the authority to be there, that's what comes to my mind. Also, I know that no one is given permission from me to be in the other 14 units. That's what I know. That's why it appears to me to be that way.
Okay, thank you, Mr. Brown. Do you have a follow-up question, Mr. Napier?
Yes, I'm saying no one needed his permission if the business was in an agreement with Venture Properties, which he agreed to in 2020. Russell had the authority to lease those units and do contracts because he was under a purchase agreement.
Hang on, Mr. Napier. Ask Mr. Brown, did or didn't Mr. Martin or Mr. Martin have the authority to lease those units? And then let him answer, because I understand the point you're trying to make, but I need you to ask it the right way. Go ahead, Mr. Napier.
Did Mr. Russell Martin, when you guys decided that you weren't doing business together or whatnot, did he have the authority to lease out units to people?
Not at all.
Okay. Did you put that in the purchase agreement?
The purchase agreement was to purchase the building, not to lease it out.
Why would somebody purchase a building, 15 units, without the intentions of leasing out the other units?
Well, he didn't perform. He was working on the building. He was getting it in a shape that would be fundable from a lender, is what he told me. But no, we did not give him any authority to lease any units at any time.
Did you meet with Kenrick Johnson on the property?
That one time.
Were you intimidated by Kenrick Johnson?
It was a very uncomfortable experience with his sister's attorney present at the time. So, he could speak to it as well.
Yeah, he will. Were you confronted by a resident or anybody with a video that had a camera recording you on the property?
Yes, I was.
Were you intimidated by that person?
Yes.
Did you tell them that?
I said, what are you here? What are you doing? I don't know you. I didn't give you the authority to be here.
And they responded by handing you paperwork of one piece of paper?
Yes.
Okay. you just, I guess you just didn't know what was going on with Russell.
Your Honor, I would just object to asking the answer.
Just don't.
I agree, sir. Excuse me, sir. I'm speaking now, and when I'm speaking, you're not allowed to be speaking. Okay. But the objection is sustained. Again, you have made your point. He didn't have visibility into the operations of Mr. Martin's business. I think you've established that, so we can move on from that issue.
Well, since we established that, and he's saying Russell didn't have the authority to lease out properties, were you intimidated by Russell, Mr. Martin?
Mr. Martin was an interesting person, but no, he didn't physically intimidate me.
What made him interesting?
He was belligerent in his speaking.
But in any other terms, you know exactly what he would do as a person if he was a belligerent speaker and a person who would force people out of the property.
I think he was unpredictable. And I think that's why many people were estranged from him, because at one moment in time, he would be your friend. And at another moment in time, it was a Dr. Jekyll, Mr. Hyde situation.
Okay. I understand your attorney's position. He's hired to represent you. But there was no default letter sent in the terms of the contract. Did you send any literature showing that the purchase agreement, outside of the signatures, I saw him put the exhibit up. Were there any documents that you sent to show that this agreement was not being paid on?
Oh, yeah.
Your Honor, I want to object as asked and answered from earlier in the testimony.
Okay.
Okay.
I remember, hang on. I remember it being asked. I don't necessarily remember there being an answer, so I'm going to let Mr. Brown answer. Mr. Brown, go ahead.
So he was supposed to pay the taxes, and based upon what you submitted this morning, there was a tax check paid and it was returned by the city according to the papers that you submitted. So we were shocked to learn that he had not paid the taxes, because we believed him when he said he had paid the taxes. So we have paid the taxes now, and they are paid up for the rest of 2021 and all of 2022. So we're the ones that paid that, along with the insurance and other expenses that we've paid on the building.
Okay. A couple of questions and I'm out your way. Are you familiar with Venture Partners, ATL LLC?
I've answered that.
No.
He's already answered it, Mr. Napier.
What did he say?
Several times.
I don't remember that answer.
He said he had no involvement in it.
Okay. Well, if you look at the last page of the contract, it's signed under Russell Martin Venture Partners, ATL LLC. He knew who the company was because he signed a contract.
But do I know anything about that?
That's not my
enterprise?
question.
No, I don't.
Okay. So you made an agreement with the enterprise that you signed, but you didn't know what it was.
Until that night when we sat down together over Chinese deal.
No further questions.
Dinner, I knew nothing about it.
I don't have anything else to say. I'm sorry, Your Honor. That's it.
Thank you. Mr. Bishop, any follow-up questions for Mr. Brown? Well, actually, I take that back. I actually have a couple of follow-up questions for Mr. Brown, just to make sure I understand. Mr. Brown, so I've been shown the purchase and sale agreement, right? And I understand enough to know that it is an agreement for Mr. Martin and or his company to purchase the remainder of the building that he didn't already own. But it was obviously intended. I mean, the agreement was initiated in February of 2020. But there's no closing or change of ownership before Mr. Martin dies in December of 2022. And so help me, I don't think I understand. Help me understand your understanding of what was the purchase, what were the terms of the purchase and sale agreement? What authority was your belief? What authority did Mr. Martin have? What were his obligations? What payments was he required to make? And did he make those payments?
So it was a bone of contention that we did enter into an agreement. He did not complete that agreement that year. It was 9 months was our agreement. He wanted 12 months and we agreed to 9 months. He did not get that complete. And then he asked me for more time and I was just lenient rather than agreeing to it. I just was lenient and didn't push him out.
Okay. And so I understand that. But so if it was a 9-month agreement, when he was supposed to perform by December of 2020, is that right?
That's correct.
Okay. And he didn't, and you just sort of let it continue, even though your perception was that he was not performing under the terms of the contract.
Well, I knew for sure he wasn't performing. And I said, we're losing money every day on this. And you have to be responsible around what we're doing and what we have as expenses ourselves. And so he said, I'll pay the taxes. And then he didn't. So that's where we're at right now.
My brief review of the PSA indicated there was supposed to be some sort of down payment.
He did pay that.
Okay. And did he make any other payments to you for the purchase of the property?
No, he did not.
And he was supposed to be paying the taxes, but you said you subsequently learned that he did not pay the taxes for 21 or 22.
He paid part of 2021, I believe, but he paid none of 2022. So we have paid the rest of 2021, which had been sold to Vesta Partners. And we had to buy it out of tax lien status. And we had to pay for 2022.
Okay. Thank you, Mr. Brown. Those were I didn't have a clear understanding of what your belief was about what performance was required by Mr. Martin. And so therefore what performance had not occurred. I guess one last question I do have is it fair to say that because you believed Mr. Martin was purchasing the property or was undertaking activity to improve the property or whatever it was, that you weren't actively managing the property, right? Like you weren't actively attempting to rent it. I think I saw something about that there were let me back up and ask a better question. You were not actively managing trying to rent the units that you had, or were you?
I was trying to, and he was blocking it. And he would not let me come on the property. I said, well, show me proof that you have done any work there. And then he would give me little snippets, not even enough to, when you see the condition of the building, you'll understand that he just wasn't doing anything to restore the building at all.
Okay. Thank you, Mr. Brown. Mr. Bishop, do you have any follow-up questions?
No further questions from Mr. Brown, Your Honor. Ready to call our next witness.
Okay, thank you. Mr. Brown, you are excused as being, from being a witness. Mr. Bishop, go ahead and call your next witness.
We call Mr. Terrence Napier for purposes of cross-examination.
Okay. Mr. Napier, will you raise your right hand? Do you swear the testimony you're about to give this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you, sir. Go ahead, Mr. Bishop.
Thank you, Mr. Napier. My name is Tyler Bishop. We've been together for about an hour. Appreciate your time. I promise you that I will try and listen to your whole answer before I respond again, so I don't get caught up in how it switches back and forth between people talking. And if I mess up on that, please let me know. I want to be respectful of what you have to say. I'd like to start with the versions of the purchase and sale agreement that I showed earlier. Were you able to see those?
Yes.
Okay. I would want to ask you some questions about them. Do you want me to put them back up again, or do you think you remember?
I have copies right here in front of me.
Okay. All right. So on the copy attached to our counterclaim, you're not listed as a signatory, right?
Absolutely no.
Okay. And then on the copy with Mr. Johnson's name, you are also not listed as a signatory, right?
Right.
Okay. So we agree then that you have no interest in that purchase and sale agreement.
I don't agree with that.
And tell me why.
Because the purchase and sale agreement was part of the documents that was used to get me to invest into the property.
Right, but do you understand that what they show you versus what you have wind up having a legal right in are two different things, right?
Right, I understand. I put up money and I was securing it. I thought it was secure through the building. If I wouldn't have been shown this contract, I wouldn't have invested money into it.
Yes, sir. I hear you, but we've just established that you don't have a right under that contract. Right? You just agree with me. Your name isn't on the signature block for either of the versions of it.
The only objection, disagreement I have with that is that when you invest money and have different contracts, based off of this contract, I am a lien holder technically. So this contract is relevant to me.
Well, so I hear you and I want to get there. I would ask that you please answer my questions with yes or no. And then if explanation is required, I'm happy to hear it. So I want to make sure we have a claim for the judge. We agree that on the face of that contract, you don't have any interest. It doesn't reference you at all, right?
I don't agree.
Okay. Can you show me on this contract where your name is?
Venture Partners ATL LLC.
And is it your position that you have an ownership interest in Venture Properties ATL LLC?
Absolutely.
And what is your interest?
My interest is to get my money back off of what I invested. It's over $600,000. That's my interest.
And so when I say interest, maybe I'm using a legal term of art. Do you own stock in an LLC?
No, we just have an agreement, a couple of documents that was presented to me from Mr. Johnson and Mr. Martin, which were used to get me to put the money up. I was investing into Venture Partners LLC, and I was told and given documents to show that I had at least 10% stake in Venture Properties LLC. And once they sell, I will be paid or in increments before they sell with the last disbursement of money I had gave him. Because he had a lot of people just giving him money, I guess. But yeah, I'm not just going to say I don't have interest.
Sure. Well, the difficulty, Mr. Napier, is I'm not going to ask and answer my own question, but you have said that you have an interest in the contract but cannot identify your name anywhere, and you have identified yourself as some kind of stakeholder in Venture Partners ATL.
Yes.
Are you aware that company is out of compliance with the Georgia Secretary of State?
Compliance of an LLC, if you do an agreement, compliance doesn't make you not liable to the agreement that you made under the LLC, unless you file Chapter 7 or Chapter 13, right?
I'm not going to answer your legal question, sir.
It's not a legal question. It's actually an answer. He didn't file bankruptcy or anything. So I would be under the impression whether he was compliant to pay $200 to bring his company compliant through the Georgia Secretary of State or whatnot. I don't think it matters if he's compliant or not.
Well, I'm just probing the depths. You say you have an interest in this company, but you're not taking any steps to make it work like a legitimate business. I'm just asking why.
I have other businesses I'm working on. That's not really necessarily a question to me. I don't live there. I just got money tied up in there.
Okay. Well, I appreciate that you. Okay, I hear you. I'm sorry. You said you want your money back.
Absolutely.
Okay. I don't mean to cut you off. I'm sorry the delay on this sometimes. I guess what I'm getting at is this: whatever interests or contracts you may have signed with Mr. Martin, that really goes through his estate, right?
I didn't sign a contract with him when he died. I signed a contract before he died. So now it will go through his estate, right?
Right.
But originally we filed the lawsuit because I didn't even know Mr. Martin had passed. I was trying to figure it out because at first I was under the impression that I was kind of getting, my tail pulled. But then once I found out that could be the case, I'm like, I need to do whatever I need to do to secure my investment. And once Mr. Brown had showed up and telling residents and everybody got to go and I'm taking over, it disturbed me. When they called and told me about it, it disturbed me because it also kind of put me at odds with Mr. Johnson.
Does it disturb you to be trying to recover money on contracts that don't give you any explicit ownership interest or property interests, like you say Mr. Brown's conduct did?
Say it again.
I guess my question is this. I mean, you know, you filed this lawsuit, you said, right?
Absolutely.
But you're not an attorney, right?
Absolutely not.
So you cannot bring this lawsuit on behalf of anybody but yourself, right?
You don't have to. Actually, that's not correct.
Have you ever heard of the unauthorized practice of
Mr.
law?
Bishop, that's a legal question. And so I am aware of what the rules are about the fact that Georgia law prohibits an individual who is not a lawyer from representing a corporate entity. Mr. Napier may or may not be aware of that because he is not an attorney. But go ahead.
Thank you, Your Honor. And Mr. Napier, what I'm trying to get at with you is you're telling me about these contracts, you're telling me about your money, you want it back. I hear it. I don't have an opinion on that. But what I would ask you for is, do you have any contract that says you have an ownership that says Terrence Napier, by virtue of ownership in venture partners or anything else, has an interest in the property at issue?
Absolutely. And that's this emergency hearing. I'm not a lawyer, but I do a lot of business. I understand. The thing is, these things that we're going to present after a lot of things were taken out of Mr. Johnson's unit and Mr. Russell's unit, yeah, that will be presented when we have some sort of deposition through discovery. We will be presenting all of these things. This was an emergency hearing. I had a million things to do. This was important enough for me to stop what I was doing and engage. But of course, we're not prepared for trial. And that's why Mr. Johnson and myself were the ones who decided to take it to court. And that's why Mr. Johnson, who's intimidating everyone, was the one that filed a protective order against your client. All of these are plaintiff things that's been filed. We wasn't trying to defend anything, we're trying to get an understanding. And the best way to get an understanding is through court. This emergency injunction of trespassing and destroying property was just ridiculous to me. And we wasn't prepared for a trial. And when we do have a trial, which we would still be seeking, we're going to have lawyers. But this was an emergency. We're not just going to hire anybody just to show up that don't know what's going on, because you could tell a lawyer anything.
So I just want to ask one question to summarize, or maybe a couple. To be clear, your testimony is you did not bring all relevant evidence to a hearing about restraining you from being on the property. Is that your testimony?
That's not my testimony. My testimony is that all the evidence that you're asking for will be turned over in discovery once we have everything. Of course, we're not ready for trial. Wouldn't sit here and try to have a trial. I'm just going against the fact that he's calling everybody trespassers, looters, and everything under the sun. It's irresponsible. He had police officers pull up over there and harass some of the tenants and all of those things. I think it's irresponsible, and that's why I'm speaking on it. I'm not trying to have a trial today, sir.
Mr. Napier, did I ask you if you were trying to have a trial today?
I'm telling you.
I'm sorry. I need a yes or no answer to that question, Mr. Napier.
Yes.
I did. I asked you. Okay. Are you aware of the litigation privilege, Mr. Napier?
Yes.
Okay. Can you tell me what that is?
No.
I'll just tell you, it means that things you say in pleadings are not irresponsible. It's a privilege afforded for folks to try and set out their lawsuit, which even if you're not having a trial, a hearing like this is what you call an interlocutory hearing to ask for relief between now and trial. And this will be my last question. Do you understand that the goal that we're looking for at this hearing, we're asking for the court to tell us who can and cannot be on that property? Do you understand that's the ask that we're making?
No.
Okay. Is it also your testimony that you came with no documents showing any right for you to possess or be on the property?
No.
I don't think I have any further questions for Mr. Napier at this time, Your Honor.
Okay. Mr. Napier, you now would be the appropriate time when I said earlier that you were testifying a little bit. Now would be the opportunity for you to do that, right? To tell me what it is you would like for me to know. I'm going to tell you a couple of things. One, I'm going to ask you to try and refrain from making an argument, right? Like try to refrain from telling me how the case should be. What I need you to do is recite facts for me the same way someone would be, you know, if you had a lawyer, you would be taking the stand and the lawyer would say, you know, Mr. Napier, tell me your name. Mr. Napier, how do you have an interest in this property? Mr. Napier, tell me how you know Mr. Martin. I'm just giving you examples, right? Mm-hmm. So so I'm just trying to give you some parameters for how you might go about doing that, because it's always a little weird when you have to testify on your own behalf, and you're doing it by yourself. So go ahead, Mr. Napier.
Well, I just want to make it clear that I don't feel like Mr. Johnson is a trespasser or looter. He has no reason to be. I invested into the property because Mr. Martin's documents and my relationship, if knowing factually that Mr. Johnson had been there for the past few years, because I would go visit sometimes. I think one of my biggest problems, though, is that I just think that this is a big misunderstanding, because I don't think Mr. Brown just knew what was going on with Russell's business affairs. And I don't think that Mr. Johnson or tenants over there should be kicked out or ejected because of business practices that Mr. Russell had undergone before he passed or whatnot. So when I hear a statement about trespassing and all these things, of course, those things are criminal activities. So whether you're saying it in court, whether you're saying it behind closed doors, whether you're saying it to somebody having a coffee, when you accuse people of doing criminal activities, that's actually alarming, because criminal activities can cause police involvement, which police have been called over there several times. And that's why we decided to, when they was telling me everything that was going on, I'm like, man, look, we can only handle this in court. So I just think that ejecting people where you don't even know who you're ejecting, because you don't know who lives there. You don't know anything based on not being around. So to make that accusation about how well you know someone and not have the facts, I think that's kind of irresponsible as far as business is concerned. And if that's the case, and you have people over there with children and everything else, if you're going to do that, just kick people out, at least use the marshals or evictions or whatnot, so they can have a chance to pay or defend themselves. But he's not only going against just Kenrick or myself as an investor or Teague, he's going against people who live there. He's expecting to have an emergency junction and have people go over there and be ejected, and they're not even part of it. They don't know what's going on from the back end. So I just think it's nobody's trying to destroy the building. I think that Mr. Johnson will be able to prove on his own that he's been the one there making all the enhancements. He's know everything about the building. He has videos, pictures from the roof. He understands that building, the science of that building like no other. He understands that building more so than Mr. Martin did. So I've trusted him. I invested, I believe. And my thing is that I think it would be inappropriate and irresponsible for business people to say that, and you really just don't know. I think you should have a better understanding of what's going on before you start using a legal system that's going to affect other people who just innocent. They're just living down there innocently, and now all of a sudden we're in court over even representing people that he don't even know. I just think he doesn't know, and I think that it should be tried as we file this case. I think those facts can come out, but I just don't think I don't think it's fair. And I think Mr. Johnson, I know Mr. Johnson's not a trespasser. I wouldn't invest in a trespasser. I don't know exactly what's going on or what happened with Mr. Martin. Maybe I got scammed, maybe not. But I invested in the papers that I saw, the contract and the taxes and all these documents he had. And I also believed in it because he had reputable people putting money behind him, like Mr. Hunter, who will be testifying and subpoenaed to court. So That's pretty much it. I just don't think I think the kicking people out of where they live and he don't even know. And I know for a fact that Mr. Johnson lives there. He's been there for years. It's disturbing to me. That's all.
Okay. Mr. Napier, I'd like to ask you a couple of questions. You don't live in this building, right?
No, absolutely not.
Okay. And so I understand that you've indicated that there are some tenants that are living in the building. Usually when a tenant is living in the building, they're paying rent for purposes for permission in exchange for the ability to live there. Do you know if those tenants are paying rent?
Absolutely. They was paying Kendrick Johnson directly for the past year or so, and he had to show that to me. So he would be the one. That's why a lot of the utilities were paid. And Mr. Martin was a money order cash guy. And I know Mr. Brown will have to attest to that. So Kendrick had total possession of the property. He collected rent from tenants. And sometimes I was there when they would pay him and he would take the money and give it to Mr. Martin at a later date. I would just be down there hanging out because I had interest in the building across the street. And I've been knowing Mr. Johnson for 30 plus years.
Okay. So, Mr. Napier, the reason I asked you that question, though, is, and I think you may have really already answered my second question, which is, so you aren't receiving any of that rent, right? I mean, I understand that from a business perspective, but the people that live in that building, they're not paying any of that rent to you. Is that right?
Right. I don't get it.
Okay. And so all of that, the reason I'm asking those questions is, as I understand, the larger lawsuit that you guys have brought claiming an interest in the property because of the purchase and sale agreement and your association with the property through the Venture Partners Atlanta. I understand all that, and I agree with your characterization that those larger issues are something that we will get to trial. But what Mr. Brown and the Buckhead Preservation Trust are asking today is to simply enter an order that says, that says only he, Mr. Brown, can control access to all the units that he owns because he's the person who owns them or the company entity that owns them. And so my question to you for purposes of today is why are you opposed to the request today that Mr. Brown be able to control who enters and exits his property? I understand there's a bigger issue where you say, but you think you have an interest in that property. But for right now, on paper, it's his property. Why do you care or object to his request that he be able to control who enters and exits?
I guess it's a difference of that's more of a Kendrick question, because my interest is when I saw the documents and saw the accusations, I don't want my friend to be homeless. And I know that he's innocent and I've given money or whatnot. So an ejectment is saying, okay, he can't even be there at his own place. And I've met a couple of people that live there. It's just, I guess it's more so of a compassion thing because I wouldn't do that. That's all. Kendrick has more interest in the ownership, the deal that has his name tied to it or whatever. So that's more so an issue probably for him to answer.
Okay, I understand. That's fair enough. Thank you, Mr. Napier. I appreciate that. Anything else, Mr. Bishop?
Just one follow-up. Mr. Napier, would you tell me the names of each and every individual you understand to be living at the property?
I know first names, don't know the last name. And I don't want to give an alias name or anything. They'll be listed in the witness list, I'm pretty sure, for I guess trial purposes. I don't live there. I don't just know all these people personally, but I'm there. I was there enough to see people go in and out, coming out with food out of refrigerators. I see babies. I see active living at that building.
Sure. And do you know any of the names of those people?
I just know one.
Okay, which one is that?
I know Tia Johnson.
Tia Johnson.
Yeah.
And is that the Tia who's online right now on the hearing?
Yes.
Okay. Is she related to Kendrick Johnson?
Absolutely not.
Okay. Is there anybody in the room with you?
No, I got lights. I'm in a room by myself.
Okay. That's all I've got.
Okay. Thank you, Mr. Bishop.
Thank you.
Mr. Napier, anything you want to add before we move on?
No, I don't want to add anything.
Okay. Thank you, sir. What you are excused as a witness, Mr. Napier. Mr. Bishop, you may call your next witness.
We'll call Kenrick Johnson for purposes of cross-examination.
Okay, Mr. Johnson, can you please turn on your video? Thank you, sir. You anticipated my request. Thank you. Will you please raise your right hand so I can see it in the camera? Thank you. Do you swear that the testimony you're about to give this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, thank you, sir. You may lower your hand. Go ahead, Mr. Bishop.
Thank you, Your Honor, and good afternoon, Mr. Johnson. You know me by now. We've been online for a while this afternoon. My name is Tyler Bishop. I represent the defendants. Thank you for your time. Just like I told Mr. Napier, ground rule, I'll ask you a question. Please try and respond with a yes or no. And if you need to explain, that's fine. I'll do my best not to talk over you. I ask you the same. Sometimes, it gets caught with the Zoom, and I want to hear what you have to say. So I'll extend that courtesy to you if you'll return it. And if we have a Zoom glitch, we'll just do it all a second time. And so I appreciate that. Let me start with, when did you first meet Russell Martin?
I've been dealing with Russell since about I want to say 98, 99, around that area.
Yes, sir. And how did you first meet him?
I met him doing a demo job. I was doing a demo job at somebody's house, and he was over there just talking and whatnot, because I do a lot of demo projects and junk removal deals and stuff.
And so this was not, to be clear, at the property we're talking about. This is some other property.
Yeah. And then we just been keeping in contact, hanging out ever since.
Understood. How did you first come to the property at issue?
I moved one of the tenants out.
And when was this?
I want to say maybe around 2000, 2001, 2002. No, it was a long time ago. I don't remember around what year and date or anything like that.
Understood. And so you currently reside at Unit 11, is that correct?
Yes.
And you've been living there since 2016, is that right?
I've been living for a long time.
Sorry, force of habit. I just realized we don't have a court reporter, and I was like, wait, is that a yes? But I realized there's nobody taking it down. So go ahead.
And so how did you first come to live in Unit 11?
Well, me and Russell was doing deals here at the property. I was doing all the maintenance on the land. I was pruning the trees, fixing the fences. There's a tree growing up against the back wall. I had to prune that because neighbors kept complaining about it. It kept getting too big. And from there, he was talking about how he was trying to buy this property from somebody. He wanted me to invest some money with him on it. At the time, I didn't really have the money, so I turned to somebody that did. And, I had to convince him to come over to meet Russell, and we went from there.
So did you ever sign a written agreement with Mr. Martin to take up residence in Unit 11?
Yes.
And I didn't see that attached to the lawsuit. When did you sign this agreement?
I signed this agreement a while back. Me and Russell signed plenty of different agreements on different occasions for different things, for different reasons.
Okay. But in terms of tenancy, an agreement for you to stay in Unit 11, what year did you sign that?
From the time, well, let's see, what year was it? I have it on the, you know what? I can't get the paperwork because he broke in the unit and he took all my paperwork. I had to look through some more, see if I could find a date on it, but he took most of my stuff out of my units, like my guns, stuff like that, my weapons. He took those also. But go ahead.
And when you say he, are you referring to Mr. Napier?
No, I'm referring to Mr. Brown. He
And
broke in the unit and stole items out of my unit. So the paperwork was missing. The unit was trash. My weapons was missing. And that's what you asked me. So
well, and so when somebody signs a contract for them to live somewhere, they typically know how long they're allowed to live there, right?
Right.
Okay. So you don't remember when you signed this agreement with Mr. Martin, correct?
Well, I don't have a date. I
Okay.
can't remember it offhand. It was mostly like month to month, but
Okay, it was okay. But when did it expire is my question.
I didn't have the expiration date basically because I was steady here on the property doing all the work. And my expiration date is when the building has sold. So I can get my money for all the work and the sweat equity I put into the building.
Okay.
You know, I'm up under the ground. I'm doing plumbing. I'm dropping ceilings to put new lines in. I'm doing everything. I'm painting. I'm pressure washing.
I'm hearing you. I just I'm going to use a legal term of art. It's not a trick question. Have you ever heard of the statute of frauds?
Okay. What does that have to do with anything?
Well, it's a legal rule that says if you have a contract that's going to take longer than a year, it's got to be in writing. That's not a question. I'm just telling you because I want to have a level playing field with you. I know you're representing yourself. I guess my question is this: is the whole issue today is whether you have a legal right to be there, and what you're telling me is there's some piece of paper which conveniently says you do, but we just haven't seen it.
Yes, I live here. Been living here for a long time. And I got money and time invested.
Yes, sir. But
forgive me, Mr. Bishop, for interrupting. Quick question. Was Mr. Martin also living in Unit 11?
No, Mr. Martin moved to another unit.
Oh, okay. Do you know which one?
Yeah, he was supposed to be in 12 after his surgery because we had it all set up for him. I was putting a new bed in there for him, so that's where he's going to be at. But I mean, because we all had 2 bedrooms, so sometimes he stay in 11, and sometimes he'd go to 12, whatever. Because I had 11 set up where heat, TV, everything you need to day-to-day basis.
Thank you, Mr. Johnson. Sorry for the interruption, Mr. Bishop.
Not at all, Your Honor. We appreciate it. Thank you. All right, Mr. Johnson. So, I guess moving right along here. I mean, isn't it true that nobody was living there other than Mr. Martin in January and February of this year?
No, I was living there. I wasn't there all the time because I do a lot of demo work and junk removal. So sometimes I go out of town, other places do works, and I come right back.
Well, and so you're a businessman. You understand, like when somebody invests sweat equity for like an ownership interest, you sign a written agreement, right? Mm-hmm. Okay, but you don't have. You said you had an agreement for some amount of tenancy, but you don't have a written agreement to own Unit 11, correct?
Yes, I do.
Okay. Why is that not attached to your lawsuit?
Terrence Napier is my partner on it, and I give certain things to him. But at the same time, me and Russell was partner on everything in this building, as far as the venture properties, everything that's dealing with this building. Me and Russell was partners. So we did everything together, and we lived like brothers, best because me and him stayed in the unit together. We cooked together. We did a lot of stuff together.
I hear you, but I guess what I'm just asking is, anything that you co-owned with Russell, you'd have to go get out of the probate estate to own it entirely yourself, right?
Right, and my name was on a purchase agreement. I signed it that night. Me, Russell, Mr. Brown, pulled up. I remember the whole dinner meeting that he was talking about. I remember all of that.
Okay, so you were at the dinner place with him?
No, I was at the building.
Okay.
And that's where I met them at. But I do have text messages. I can try to look and see.
Well, I appreciate
phones.
I appreciate that. Yeah, no, what I'm getting to is, as the judge told Mr. Napier, what we're talking about today is determining who has the right to be on the property and who doesn't. And so, my question is just, if they existed, why didn't we see them at this hearing? Why weren't they attached to your lawsuit? I mean, it seems like claiming ownership interest in a condo unit or an entire building is important enough to document.
Mr. Bishop, I'm just going to say, if there was a lawyer here, he would be objecting to your argumentative questions. So let's try and keep it to asking him about facts. Thank you.
Understood, Your Honor. You heard Mr. Brown's testimony about going to the Chinese restaurant to execute the agreement, correct?
I heard about that. But see,
Why weren't you
I live here. Mr. Brown doesn't. Mr. Brown hasn't even been to the building that many times. Even the 7 times that he mentioned, he probably been here less than that.
Okay.
He don't come to the building. He ain't do any of the maintenance, any of the tools and stuff that's here. I purchased those tools. I'm the one that's doing all the work, so I had to break all the tools in. He don't have no equity inside this building whatsoever, besides his name being on paperwork. Like my name is on paperwork. All of our names is on paperwork.
Okay.
And
so
him and Russell didn't get along. Me and Russell was kind of cool, interested. No, it wasn't like that. Now that night when they had their meeting, I wasn't at the meeting at the restaurant. They talked. Russell already told me about that, but he said he's going to bring him here so we could all sign them. But
Okay, well, let's dig further into that. I'm going to share my screen with you so we can take a look at these these agreements again. Please let me know when you can see the screen share. Can you see what I got on my screen?
Yeah, I see it.
Okay, so I'll just represent to you. This is Exhibit A that we looked at with Mr. Brown and the signature page and of the document we attached to our counterclaim, and you would agree with me that your signature is not on that document, correct?
I don't know what type of wizardry that Lou done to not have my signature on that document, but to me, I filed a restraining order against Lou because I'm afraid of him and afraid of the things that he can do. Like the things he tell me, hey, I got big powerful lawyers and I got judges on payroll. You'll be out of here in 30 days. That's what he told me.
I'm not about to be taken down for bullying again with papers on the screen.
I want to look at with you one of the documents that you tendered. Can you see what I'm showing you now?
Yeah. Let me see if I can.
Are you looking at a document that's called dismissal of temporary protective order? I'll zoom in.
Yeah.
Okay. You mentioned that you went and got a protective order against him. I was wondering if this is what you were referring to.
Yeah, I was filing that. Yeah.
Okay, so you agree with me here that where it's checked, it says it's checked because petitioner failed to prove by a preponderance of the evidence repeated facts of surveilling and contacting. Those are the boxes that are checked, right?
Let's see. Okay. Yeah, but do you agree that the sticky note right there is what a judge just said, right?
I'm
right
sorry,
there.
Mr. Johnson. I'll ask you a question.
Okay.
So I read the check boxes correctly, right?
I believe so. You read the check box correctly. Now, can I ask a question?
No, sir.
Did you read? Oh, I can't. Okay.
No, sir.
Mr. Johnson, as I was telling Mr. Napier earlier, you'll have an opportunity to testify on your own. But I will say, in fairness, if you don't understand the question that you are being asked, you may ask for clarification of the question.
Okay.
So go ahead.
Well, and so I just, the reason I showed that to you, Mr. Johnson, was just so that we could agree that there was never a protective order entered against Mr. Brown, correct?
I want to file another one in Fulton County.
You said you want to?
I did. I found another one in Fulton County, and I'm waiting to serve him.
Okay. All right. So I want to, going back to talking about the contract, can you still see my screen?
Yeah, I can see him.
Okay, and this is the version with your signature on it, right?
Yeah.
Okay. And so is it your testimony that this was the original document as signed at the Chinese restaurant, and then it was brought back to you and you signed it separately?
Let's see. Hold on, why would I sign something separately? Why wouldn't we all sign it together?
Well, because you told me you weren't at the Chinese restaurant.
Yeah, but don't mean that the document was signed at the Chinese restaurant either, right?
So are you telling me then that it's your testimony that Mr. Brown and Mr. Martin did not sign it at the Chinese restaurant?
My testimony was answered earlier.
Hang on. So it would be helpful to me because there's a lot of question. It would be helpful to me to just ask directly. So, Mr. Johnson, when you signed, I think I understood you to say that you signed the document at the apartment building that evening. Is that right?
Yes, they came to the building.
Okay, and when you signed the document, were Mr. Brown and Mr. Martin present?
Yes.
Did they sign the document in front of you?
Yes.
Or had they already signed it?
No, they signed it first on top of the car.
Okay.
They signed it first. I was the third person to sign.
Okay. Thank you, Mr. Johnson.
And thank you, Your Honor. And I guess, Mr. Johnson, do you remember what Mr. Brown was wearing when you all executed this?
I don't recall me looking at his attire to say, hey, I make sure you got on a blue tie or anything like that. No, I don't. It was maybe somewhere like like a polo shirt and pants, maybe.
Okay. And
I'm not for sure.
Okay. And you said they signed on top of a car, right?
Top of a car.
You said that's where the contract was signed, right?
Yeah, on top of a car.
Okay. What type of car was it?
Red BMW.
If I share my screen back with you real quick, I guess I just want to ask you, you made a comment earlier about the version of the contract attached to the complaint. I guess my question is, here where your signature is on the other document, does it appear that it's been altered in any way or that things been whited out?
Well, I'm not for sure either way. I mean, I figure that's what we're going to court for. So all the evidence could be put into play then. But I'm not a professional at seeing if anything been whited out or anything like that. I'm not.
And so what time was it when you signed this contract?
Long time ago. I don't remember the exact time. I couldn't
sun...
tell you it was Monday or Wednesday. I couldn't tell you it was 6 o'clock, 8 o'clock.
Okay. So you don't know if the sun was up or down?
Mr. Bishop?
It was more.
I feel like you've made your point. We are still in a TRO. This is not the full-blown hearing and the full-blown trial of this matter. And so I feel like we can move on.
Understood, Your Honor, and I'm happy to do so. Mr. Johnson, let's switch gears. When did you first learn of Mr. Martin's death?
Pretty much what Lou told me.
Okay.
I mean, because I received a few phone calls. I went searching for him, especially when I didn't hear anything from him. When Lou had started going to all the units, I was trying to get into contact with Russell then. But I couldn't get anything because I knew he had surgery and I know about HIPAA rules. So, I can't really get any information.
So you knew that he was in the hospital?
Yeah.
Which hospital did he go to?
Piedmont.
Did you take him to the hospital?
No.
Did you visit him in the hospital?
No.
When did you first learn that Mr. Brown was coming to the building?
One day it rained real heavy, and I just got back in town from visiting my parents up in Cincinnati. And I see two of the doors kicked in. So my first thing was to call Russell, leave him a message, because I figured it had to be Lou, because he always told me that Lou might try to come and take the building from him or try to lock him out while he's gone. And my job is to make sure nothing like that happens, to be here on property so I can confront him like, hey, Russell will be right back. He's in surgery, whatever case may be. Because they never liked each other for whatever our reason. And he felt like Lou was always trying to do some shady stuff towards him or extort him or whatnot. I don't know all the details, but we did talk a lot.
You were online when Mr. Napier was cross-examining Mr. Brown, correct? You could hear the proceeding?
Mm-hmm.
And you heard Mr. Brown say that he had a key to the units, right?
He lied.
Or is it your testimony that the door was kicked into Unit 11?
When I got to Unit 11, everything's been changed. The lock has been changed. Two of the other units' doors are still cracked open from it being kicked in. So I don't know how he got in 11, but he was in there. Then he called me and openly admitted that he was in 11. Oh, I walked in 11 and I was in there and you were not in there. And I'm saying, how do you know where I'm at, what I'm supposed to be doing? You weren't even supposed to be in 11. Then I asked him what happened to my weapons. Oh, well. And then he went on and talked about something else. I kept repeating the asking. So before I did anything as far as calling the police, I figured that once I talked to Russell, because I knew their relationship, I could get Russell to get him to give me back my weapons. So it wouldn't have to go that route. And then here we are, after he done sent numerous amount of people jumping over the fence, some of my tools come up missing. I mean, that's scary to me. Imagine you at home and you walk outside and someone's jumping over your fence, walking around your property. That's a scary sight, right? I mean, somebody at your house, you don't know what's going on, or you pull up and somebody's just randomly coming out of your apartment or your house. That's a scary sight, right?
I'm sorry, Mr. Johnson, I'll ask the question.
Oh, okay. But you can't answer that one?
I asked the questions, Mr. Johnson. So let me ask you this. You're living there and the maintenance teams that Mr. Brown hired show up to do work. You'd think that's pretty normal, right?
I didn't see a maintenance team. All I seen was guys jumping over the fence, coming in. If it was a maintenance team, they'd come through the front. Or they could have called my phone, right? Could have called my phone. Hey, I'm the maintenance team here.
Is your testimony that people were jumping the fence before or after you changed the gate locks?
People's been jumping the fence before, during, and after.
So, but you've just admitted to me that you did change the gate locks, correct?
I'm not admitted to you that I changed the gate locks.
Well, then why would you say that people jumped before, during, and after?
Hey, people been jumping that fence, and I just been quietly asking them to leave. And I don't believe none of them name was Donnie or any place like that he had mentioned, because he kept mentioning that name. I don't recall meeting somebody named Donnie. And I met I think the guy was like maybe Mexican or something like that, but he didn't look like any plumber or electrician or like that I've known, because most time the plumber and electrician they come with a uniform on. He just like a regular old thug with a hoodie on and gold teeth all in his mouth.
So I guess my question is this: did you or did you not change the gate locks on the outside of the building?
I don't have to. I don't have to change the gate locks or anything like that.
I'm sorry, Mr. Johnson. That requires a yes or no answer. Yes or no, did you change the gate locks?
No.
So why hasn't Mr. Brown been able to get in?
Because he never had any locks in the beginning.
So you put locks on for the first time?
The last time I known anything about any type of locks being exchanged is when he had changed the locks on my unit. After he done broke in.
Let me go back. Were there ever locks on the gates to the building?
Bike locks.
And it's your testimony that you never took those off?
Oh yeah, I took the bike locks off.
Did you replace with new locks?
No, why would I replace the gate with new locks? No, I mean, those bike locks, they went through the fence and around the loop. That's the way I come in and out. Now, he didn't do he put gate locks on 2 of the gates and then do the third one. So I had to come in from the third one. I'm saying, why is these locked? They shouldn't be locked. They shouldn't have any locks on it. So I took them off.
And your testimony is they're sitting out there unlocked right now. You never put another lock on it. Anyone could walk right in.
No, they had to put a new lock on them, but that's a fire hazard to have bike chains locks on gates when someone lives in the building, right?
So it's your testimony that I could walk up right now and walk in on any of the gates. There's no locks.
I never said that. Okay. The locks on the gates are still there, not the bike locks. There's no more door locks on the gates. Okay, they've been there.
Okay. And Mr.
Hold on. As his employee admitted when he was parked in the truck, yeah, I just had to come in and pop the lock. So that's how they got in, because they popped the gate lock, and then they went from there to start popping locks to all the doors and kicking doors in.
And what time frame was this you're talking about? Was this January?
Yes.
Okay. So it's your testimony that
yeah, January. Yeah.
Okay. So you're telling me there's no locks on there now then?
You just asked me the same question like 4 times.
Hang on, both of you. This is really not that complicated. Are there locks on the gate right now?
The same locks that have been on the gate are still there.
And it is a key lock, and that's different than the bike lock thing that you were talking about. Is that right, sir? Okay.
Yes, ma'am.
Go ahead, Mr. Bishop.
Thank you, Your Honor. And Mr. Brown doesn't have these keys, correct?
Correct.
Okay, so then you are effectively in total control of the building, right?
Mr. Brown never had any keys to the building at all.
That's not the question that I'm asking, Mr. Johnson. I'm asking, he can't get in right now to the new key locks because he doesn't have the keys, right?
He been getting in by popping the locks.
That needs a yes or no answer.
He can't get in.
Okay. And you agree with me that condominium unit residents can't bar other condo owners from the property or common areas, correct?
I don't know about other condo areas or anything like that. So he's not the owner, so I don't know. I can't say what other people.
And you talked about changing locks on the units themselves. Now I'm talking about, and you tell me if I'm summarizing your testimony correctly. You testified that Mr. Brown changed unit locks.
Say again?
Is it your testimony that Mr. Brown changed locks on the units? I'm talking about the units now.
He changed locks on Unit 11.
And did you drill out that lock?
That's my unit. It shouldn't have been changed. It should never been entered.
I'm sorry. I'll ask it where you have to give a yes or no answer. You did drill out that lock, didn't you?
No.
Now, how did you get back in?
Call the locksmith.
Did the locksmith drill out that lock?
No.
How did he get in?
He's a locksmith. That's what they do. He rekeyed it.
How many times have you seen Mr. Brown face to face at the building?
I seen Mr. Brown one time face to face at the building. Maybe about 3 times in total. Yeah, 3 times in total. When first time we met, and 2 other times since then, but I haven't seen him since. Until he came back, even though he kept saying it was his somebody else's lawyer, but he kept shouting that was his lawyer. And then he came back with the police a couple times, all rowdy up.
And each time that he came by where you were there, you didn't let him in, did you?
Well, actually, the first time he didn't even ask to come in, and I didn't have to. I mean, I would stand out the way. He didn't say anything to me about coming in. He was just trying to have court in the front yard. That's it. And
so the answer to my question then is no, he didn't get let in.
You asked that I wasn't keeping him from coming in. He didn't come to the door. He just came to talk to me about court and how I should leave and how I got big powerful lawyers and they're gonna kick me out of my ass. And he got judges on payroll, and that was his whole testimony.
Well, it's not testimony unless you swear. But so I just want to ask one.
We right. Well, that's what he said to me.
And so was the first time over there? Is that you contend when y'all signed the agreement on the car?
Yeah. And he was already. Matter of fact, when I got here, because he was here before I was here, he was already inside. He was coming out.
Okay, but never inside since then on the other 2 trips, right?
Nah, he just came up with the police and was yelling, and the police officer actually told him to leave.
So other than, well, would it be more accurate to characterize the police officers as saying that this was a dispute that y'all were going to take up in court?
Yeah, we told the police officer that we got everything in court. And they said, okay. He was lying to the police officer, saying he'd never been served until we showed the police officer the video of us serving him. And then the police officer told him he need to leave the building because he's not going to, it's more of a civil matter. And,
So a couple of wrap-up questions here. Other than the purchase and sale agreement that we talked about, what documents do you contend give you the right to be in Unit 11 or on the premises?
The documents I have, I was going to show that we had.
Well, hang on. Mr. Bishop, you asked him what documents he has to show. I understand all that. In fairness, Mr. Johnson, just because you don't have them here doesn't mean you can't tell me that they exist and what you understand them to say, right? So I think it would be a fair way of asking it for my benefit for Mr. Johnson. Do you have documents that you believe give you the authority to live in Unit 11 or to otherwise have authority over the building?
Yes, I have a.
Okay.
Yeah.
And can you tell me what those documents are?
I have a lease agreement that me and Russell Martin have worked out for me to have control of all the units as far as bringing tenants in and for which units is ready and which units are not, and the upgrades and upkeeps.
Okay, and do you have any other documents? Well, hang on. Let me ask for clarification there. I apologize, Mr. Johnson. You said you have a lease agreement, and earlier you talked about a lease agreement that you had for Unit 11.
Yes.
And the one you were just talking about that you said gave you authority to like collect rents and stuff with the tenants, is that a different document?
Yeah, but
okay.
He actually a lot a lot of my documents, I believe Mr. Brown has taken out of my unit. So I've been going through paperwork and trying to find other stuff. I have a lot of email stuff I've been trying to go through to pull up stuff and dates and everything.
Right.
So
I understand that, Mr. Johnson. That's why I'm asking you that.
And everything I find, I'll make sure I was gonna give it to the lawyer that I find so he can help me go through everything and I can present stuff correctly.
Okay, I understand that. I just was, usually if we have an understanding of why we're authorized to do certain things. And so that's what I'm asking you is, and Mr. Bishop can take issue with whether you have documents or not, whether you're able to show those documents. But my question is just, you seem to have an understanding that you had authority, you had the right to live in Unit 11, and that you had authority over the building in some manner. And so
Yes.
I'm asking, what is it that gave you that belief? And I think I heard you say you had a lease agreement with Mr. Martin for Unit 11, and that you had some additional agreement with Mr. Martin for you to sort of manage the property and collect rents in the other units. Is that right?
Yes.
Okay.
Me and Mr. Martin was also business partner.
Okay.
So,
And did you have any other agreements with Mr. Martin or any other documents that you might point to that you think gave you the authority for the building?
hold on. My phone voice just went out. I might have hit the button by mistake. Hold on. Okay, I think. Okay, hello?
Yeah, I can hear you.
Can you repeat that, please? I'm sorry.
Yeah, I was just saying you've identified two documents, and then you said something about having a business interest. So do you have, was that an agreement between you and Mr. Martin that was reduced to writing at some point? So do you have an agreement with him about your ownership interest in his business or in the building?
Yes, we did.
Okay. I think that answers what I was trying to get to in terms of a more direct point. I'm sorry I keep hijacking you, Mr. Bishop. I apologize.
Not at all, Your Honor. I appreciate the help and always try and proceed appropriately with pro se litigants to make sure they have a full and fair opportunity to be heard. So
I'm going to make sure documents that I have.
Mr. Johnson, your audio is breaking up, right? So I heard you say I'm going to make sure, but I didn't hear anything after that.
I'm going to make sure all documents that I have with Mr. Martin will be submitted.
Okay. Mr. Bishop, any additional questions for Mr. Johnson?
Just to follow up, Mr. Johnson, how are you related to Tia Johnson?
No.
Okay. But she's a tenant in Unit 6, you say?
Yeah.
When did she start living in Unit 6?
She had the place for about I want to say about a year now. And I know she wanted to do some upgrades. So I told her I was going to do some upgrades in the unit for us, like, put a new cabinet in or something like that. But that's about it. But yeah, she's been.
And did she have a written lease agreement?
Yes.
And who signed that on behalf of the property?
Mr. Martin.
So you're saying that he signed it before he died?
Yes.
What other tenants are living at the property?
I asked them, would they want their names to be involved in this? Because some people don't want to be involved in anything. So, I can get them all information. They said just they don't want to be involved in any type of court stuff, but just let them know what's going on.
Well, whether they want to be involved is irrelevant, Mr. Johnson. You have an obligation to tell me their names if you know them.
Mm-hmm. So by me going to all the units to get you all their names so you can try to, evict them?
I'm not going to discuss my strategy, Mr. Johnson, but sitting here now, you have an obligation to tell me the names of every person you know to be residing there. So can we start?
I would talk to them about me giving their names, and then we go from there.
Your Honor, I'd ask you to instruct the witness to answer.
So, Mr. Johnson, it is a fair question. If you have knowledge of the individuals that are residing in the property in the individual units, I'm not aware of any reason that you would be justified in refusing to provide that information.
Okay. Well, I gotta get their last names because all of them I don't really know their names like that.
Okay,
I mean,
well, that's fine. You can only testify about the knowledge that you have, but
Yeah.
if you have that knowledge, you have to answer the question.
Yeah, no, I mean, I don't really know most of their names or anything like that, so I would have to go around and get their name. That's why I said I'll just talk to them about, and then I can go from there. But
Sure. Well, you said you'd have to get last names, so why don't you tell me the first names that you know?
I repeat, I don't really know everybody's names like that, so because I don't really talk to them on an everyday basis.
Okay. So I just want to make sure. I mean, you understand you're under oath to tell the truth, right?
Right. Okay.
And your testimony right now is you don't know anyone else's first name other than Tia. Nobody.
That's the only one I normally talk to when I see her.
Then no, sir. That's not the question I asked you. I said nobody else's first name at all.
Gerald.
Gerald.
Danny.
Okay. And what units do they live in?
See, which one Gerald live in? I think he lives in 10 and 8.
And Danny's at 8?
Yeah.
Okay. Can you tell me, if you don't know their names, can you tell me which other units are occupied? I've got 10, 8, and 6, and 11 for you. Which others?
6, 15, 14.
Hang on 1 second. Mr. Johnson, so you're moving around, and not only is that making me a little bit seasick, but also it causes the problem of sometimes you go in and out of service. So I've gotten to be a pro at this over 3 years now of doing Zoom hearings. So if you need to move, I understand that, but tell us that you're doing that. We'll take a break for a second for you to go to a different location. If you could try not to walk around while you're testifying, I'd appreciate it.
Yes, ma'am. I'm a first timer. I'm sorry.
Nope, that's fine. I totally understand. Thank you, Mr. Johnson. Go ahead.
All right, so we're wrapping up, Mr. Johnson. I've got 6, 8, 10, 11, 14, 15. Anything else?
5, 4. 4.
And that's it?
As of right, yeah. That's I believe so, yeah.
And do you understand that Mr. Russell's estate is tied up in the court system for probate right now since he died?
Not really.
Okay. Okay. Well, it's not a trick question. I'm just asking. Like, since he's dead, do you know that any business agreements between you and Mr. Martin have to be resolved with whatever happens when his estate goes through the probate court and they appoint somebody to wrap up his affairs? It's not a trick question. I was asking if you generally knew that.
No, I'll go get a lawyer, let him handle all that, and try to smooth everything out.
Okay. Your Honor, I think that's all the questions I have for Mr. Johnson. I'm ready to move to Ms. Johnson and wrap up.
Okay. Mr. Johnson, same thing I said to Mr. Napier earlier. Well, actually, let me ask this. Mr. Napier, do you have any questions for Mr. Johnson?
Can you hear me?
Yes, I can.
Mr. Johnson.
Yes.
Do you understand that the ejectment is kicking you out of your own home?
I'm sorry. I didn't quite hear that word. Could you say that again, Mr. Napier?
Does Mr. Johnson understand that this proceeding is to kick him out of his own home?
No.
This proceeding is to kick you out of your home as a
trespass. Actually, I will be in charge of what the proceedings are.
Okay, I'm sorry for trying to be a job. I gotta let handle myself. My time look, when you sign the agreement with Russell, the original agreement, did you think that you had to report to Lou about tenants or any other thing, or did you just feel like you had the authority if something happened to anybody in the deal? Because once Russell passed, did you really believe that you had the authority and the ability and authority to run the property? What would make you think that you should be the one in control of the property?
When Russell was alive, he gave me all the authority to run the property, deal with the tenants, because he didn't deal with people too much too well on certain issues, and I did. I was good at that.
You was good. Okay.
And I did all the maintenance on the property, all the upkeeps, repairs, remodels.
Did you look at the pictures that was submitted to the courts of the property? Did you look at them from that Lou or his people had taken?
Yes.
Do you have any idea why these pictures were taken?
No, I didn't.
Did those units that were outside, were they trash or did they work?
It was trash.
Because if you have something sitting outside for a long time that's electric, it may get rain on it.
Yeah. Them units
What
been
about
out there.
these sinks that were submitted? Are those trash?
Can you lift it up a little higher, please,
The
sir?
sinks.
Trash.
These air conditioning units.
Trash.
Why is this picture? What's this picture?
That's a cylinder I dropped and replaced. We had to move the electrical over. It wasn't centered. And they wanted different lighting in there besides that ceiling fan.
Where are the antiques that I heard Mr. Brown talking about? You said there was antiques in your unit.
No. Well, no antiques in my unit.
Was this contract that you presented to me and Russell presented to me, which Teague also verified, did you alter the document and add your name to the document in order for you and Russell to trick me out of investing into this property?
Your Honor, I would just object to the foundation. Teague, whoever that is, has not testified. So to the extent we're talking about verification of a document by a non-party, we would object to that foundation.
I agree with you, but I think the question itself is fair. Is he's asking Mr. Johnson if Mr. Johnson put his name on that document, and if he did, for what, to what end? And I think that's a fair question. So go ahead, Mr. Napier.
Okay, thank you, Honor. Did you guys alter the documents and add your name to make me feel comfortable with putting money behind the building, or was your name already on the document legally, and you, as you said, y'all all signed it together, and this was a legitimate document that was used to tell me that it was a cool deal to, you know, put money into it because I'll be paid back?
Yes. We legally signed the documents, gave you the original copy, so you know that everything's legit.
Are you a partner in Venture Partners ATL LLC?
Yes.
Did you guys pay taxes under Venture Partners ATL LLC, which was presented to me to make me comfortable with spending the money?
Yes.
Do you know why Mr. Brown says that he wasn't even familiar with this company? I'm confused. Do you know why, or why wouldn't he be familiar with this company if you guys showed me an agreement with all your names on it in Venture Partners ATL? I don't understand that.
He's familiar with the company.
So let me interrupt. I feel, Mr. Napier, I absolutely understand why you want to ask these questions, but, and they probably are relevant to the bigger issue about which you filed your lawsuit. But I don't know that they're relevant to the determination that the court has to make today as to whether I should enter any sort of temporary restraining order, limiting anybody's access to the property.
Okay.
So no, that's okay. Like I said, I understand why you're asking these questions and you want to know the answers to those things. I'm just not sure it's relevant to today's decision making.
Okay.
Go ahead, Mr. Napier.
Mr. Johnson.
Yes.
Have you looted or damaged anything at that property since you've been there?
No.
Have you enhanced the property or made any repairs to it recently?
Yes.
What repairs were made recently?
Plumbing. Had to go up under both units.
put new lines in, the main pipeline in.
Did you put the lines in, or did a company put the lines in?
Had a company put the lines in, so I got insurance on it. You know, for the guarantee.
What company did you use to put the lines in?
What's the name? The blue, orange.
Barty?
That's the one.
So the documents that you showed me about the estimate on the repairs, do you remember how much that was?
Like 6,000-7,000. Then we did one on the other side. That was 9,000.
When did this happen?
I want to say about a month and a half ago, maybe somewhere around in there. Actually, no. In January. I've been dealing with plumbing issues since January.
Since January. How many times have plumbers been there to repair the building?
About probably about 11 times.
Do you have the receipts showing the repair that was done and the plumbing companies that done it?
Yeah.
So when I came to the property, when I came back from Vegas, and Barty was there, and they had a whole crew there working, Lou didn't send them there to do that work?
No.
Where are the air conditioning units?
They're trash.
Where are the sinks?
Those trash.
Have you installed any new sinks or any new toilets?
Yes. Installed new sinks, new toilets.
Who paid for it?
You did.
When I came down there, and I was there today about the plumber that supposedly came, are you referring to the guy that we got pictures of and videos that was driving a red Charger with tinted windows?
Yeah, that's the one that jumped the fence.
What did you do after he jumped the fence and he came over there? What did you do after he left?
I asked him to leave.
After he left, what did you do?
I took pictures. I called Lou. I talked to Lou about it. He said, "Oh no, I sent him over there. I told him to jump the fence, but he had tools and stuff in his hand that he was taking out that I made him put back down." He said, "Oh, I just seen these."
Okay. How many weapons are you missing?
4.
Did you file a police report?
Yep. With Fulton County.
How many times have you been to the police department on this matter?
About 3 or 4 different times.
So you filed, what made you feel like you had to involve the police from a protective standpoint?
Because when I talked to Lou about it, first he kept saying that he don't have nothing to do with my guns. Then he said, "Well, you're not getting them back." Then he said, "Well, I don't know who been in your unit, but I was in there. But I don't know who took the guns, but I was in there." He just kept giving me the runaround like he want to keep my weapons, and I just have a fear that one day he may send somebody over there with my own weapons. I don't know.
Your Honor, I would just object to all this as hearsay.
Sustained.
Okay. Are you intimidated by Lou?
Yes, I am. He showed it numerous amount of times.
I saw the document that was presented. I read something about I guess I won't even speak on that. But these pictures, for instance, this is a picture of what? This is what they submitted.
Cow manure.
Where is it at right now?
In the same location.
What is this?
Hallway.
You see this? Is that gate opened or closed?
The gate.
Can you see it?
Yeah, I can see it. It look like the gate is open.
Oh. Okay.
Hold on. Can you bring it a little closer?
There it is. You see?
Oh, no, that gate closed from this
No.
angle. Yeah.
Look at it. The gate
Hey, hang on. He can't see it clearly to the extent that he can. He said it was closed and he said it was open. I mean, the picture is what the picture is.
Okay, well, what was submitted to the court? If the courts look at it, it's clear that the lawyer that he bought with him, they're behind the gate. When you were called about Lou and his lawyer being on location, where were they at when you pulled up?
They was in the front.
Where were they coming from? Where were they coming from?
Inside the building.
If you can't see it, you can't see it. Can you see that ladder?
Yes, I see that ladder.
Where is that ladder?
I'm sorry, I gotta move again. I'm sorry. But right here. I was doing some electrical work up in there. That's the ladder.
That's the ladder?
Yes, sir.
See what this is? It's another picture.
Yep.
Where is this at?
I don't know right now.
Okay. So the pictures, because when I looked at them when they were submitted, I thought it was being like you was in here damaging the place or whatnot. Do you even know offhand, if I show you this picture, do you know what unit this is?
14.
You see this?
Yeah.
When was that posted?
That was posted in, I want to say sometime.
Don't worry about it. It looked like you were upstairs.
Yeah.
You see this picture?
Yes.
How recent was this picture?
That picture was in January. Had to be.
What's back there right now?
Nothing I can show.
No, that's fine. So you're not vandalizing the place. You're not making the property value go down. You're only investing more money into the place because we under the impression that you should, based on being Russ' business partner, as if I have a business partner in the venture. If I passed or my demise was to come, I would assume that who I'm partners with, they would be held responsible for that.
Your Honor, I would just object as assuming facts, not in evidence.
Not assuming. I'm talking about what I would do.
Mr. Napier, there's an objection. Let me
Okay.
answer. I understand. I think the point's been made. Let's just move on.
Okay. Well, where do you live?
Unit 11.
Do you plan on paying me back the money that I...
Mr. Napier, forgive me for interrupting, but again, your interest and any issue is part of the larger lawsuit, but it's not part of what we're focused on today.
Okay, I'm just trying to make sure I don't have to sue Mr. Johnson also.
Okay, I understand that, and but again, any interest that you have in the property is part of the larger lawsuit, but it's not necessarily part of today's issues. Okay. Well, anything else, Mr. Napier, for Mr. Johnson?
No, my last thing is that what are you gonna do if you get kicked out of a place that you had an agreement to be in?
I'll be homeless.
That's all.
Mr. Johnson, do you have anything you would like to add on your own behalf in terms of facts that you feel like the court should know to consider what the request is that Mr. Brown, through his lawyer, has made about access to the property?
My fear of his access to the property is the dangers that he's going to bring with him. Honestly, that's my fear. From the stuff that he's been saying to me face to face, and by my weapons being missing, I just feel like something's going to happen to him.
So, Mr. Johnson, can I ask you? I would like a couple of questions. So, I think I understand the request from Mr. Brown to be that y'all should not be changing locks and limiting his access to the property that he owns. Mr. Bishop may tell me that I have a wrong understanding of what they're asking for, but that's what I think I understand them to be asking for. So, what dispute would you have with Mr. Brown? I understand you've expressed that you have some concern about your safety and that you are personally afraid of Mr. Brown. But in terms of Mr. Brown being able to access the units that he owns, right? Why would you have an objection to that, Mr. Johnson?
Original contract. The company is not in default as far as paying anything, as far as money that's owed so far. So, and him just walking into people's unit, I mean, if you was renting a house or an apartment or anything from anybody, the owner just don't come in and open up doors and go through people's houses, find out what's going on and how they living and where you sleeping at and stuff like that. That's unheard of.
Okay. Okay. The tenants that are in the different units, I think you mentioned Tia had a specific lease with Mr. Martin. The other tenants, where are they paying rent? Like, to whom are they paying rent?
Well, I normally collected them and gave everything to Mr. Martin. So,
You're cutting out on me. You normally would collect them and give them to Mr. Martin, but now what?
They stopped that he died, so I told them to wait.
So they've not been paying rent for what, February, March, April?
Just actually they had yes.
Okay.
Okay.
Okay. Thank you, Mr. Johnson. Anything else, Mr. Napier or Mr. Bishop?
I don't have anything.
I have one more question for Mr. Johnson, and that is, Mr. Johnson, do you understand that Mr. Brown entered the building after Mr. Martin's death on the request of his sister?
I don't understand that he entered the building on the request of his sister at all.
I have no further questions for Mr. Johnson, Your Honor. I would like to redirect Mr. Brown on this new gun issue.
Okay. Well, you haven't finished your original direct. If you wanted to call on Miss Tia Johnson first, or which order would you like to go, Mr. Bishop?
Well, let's do. Let me do Miss Johnson, and then maybe we can close with Mr. Brown.
Okay.
All right.
Ms. Johnson?
Excuse me.
Yes, sir, Mr. Johnson.
Ask a question. And I've never met Russell's sister, but I heard a lot about her. And I know the relationship he had with his sisters. And I honestly don't know if she even came to the property or not, because I never seen or heard anything from her. All I know is that he said that she came here. And I said, well, can you call her on a three-way business call, or can I call her and talk to her? Nothing. Okay. It just, get out, or do this or do that, or I got this, I can do this, I got power. You don't. That's all I heard from her.
Okay. Thank you, Mr. Johnson. And I think that Ms. Johnson, Tia Johnson, had dropped off, but then it looks like has rejoined us. Ms. Johnson, are you able to turn on, your audio and video?
It says in the chat, Your Honor, that she's trying, but it won't.
Yeah, I just saw that as well. If she's not able to turn on audio and video, then I don't know that you would be able to examine her as a witness. If she's able to rejoin us and is able to turn on her video, then we'll know. But at that point, perhaps you should move on to another witness.
Sure, I'll call Mr. Brown for a brief redirect, Your Honor.
Okay, Mr. Brown?
Yes.
Mr. Brown, you understand you're still under oath. I'm sorry, Your Honor. I didn't mean to.
No, I was just going to say the same thing. I was just going to remind Mr. Brown that you were sworn in at the beginning of the proceeding and that you continue to be under oath. Go ahead, Mr. Bishop.
Thank you, Your Honor. So, Mr. Brown, just as the judge said, you're still under oath, still sworn to tell the truth. Did you take Mr. Johnson's guns from his building, or from the Unit 11 that he was occupying?
Not at all.
Do you know how many guns there were?
No, I never saw any guns whatsoever.
Is Mr. Johnson taller than you?
Oh, yes.
By how much?
About a foot.
And is he?
It seems like maybe
is he
maybe not that much. I don't know.
Sure. Is he physically a bigger man than you?
Much more.
So would a man like, who's a foot smaller and all, would he be intimidating to the larger man in the David versus Goliath?
Of course.
So the shorter man would be intimidating to the larger one, or maybe?
Oh, no, the opposite. No, I'm not intimidating to him at all.
Have you ever heard of, did you sign this contract on the roof of a car with Mr. Johnson there?
That is a total 100% complete fabrication.
Did you have people jump in the fence?
Yes. The plumber, when he couldn't get into the gate, I said, well, you know how to jump. If you'll go over to that ledge, you can just jump in there and go ahead and give me the bid. I thought that Mr. Johnson was cooperating, and in fact told me he was cooperating. And I said, well, and I actually called him and I said, hey, I've got my plumber there, just wanted to let you know. And he was over at the Home Depot. He comes in from the Home Depot because of my call and chases off my plumber. So no, that's
understood. Did you ever threaten Mr. Johnson?
Not at all.
Did you ever physically bow up at Mr. Johnson?
No.
Did you ever make the absurd? Did you make any commentary on the independency of the Atlanta judges?
Not at all. That's another fabrication.
Did you make any reference to any counsel you had or had not retained in any interaction with them?
At that point, I had no counsel.
I think that's all I've got for you on your redirect. Now, they will get a chance to recross you because I asked you these questions, Lou, and I'm sorry, but I wanted to get clear about the guns.
Sure.
Thank you. Mr. Napier or Mr. Johnson, do you have any additional questions for Mr. Brown? And it just, so you understand the way the rules work, it should be limited to the topic. Like, you've already had a chance to ask him questions about other things. So if you have questions, it should be limited to the topics that were covered in this more recent question. Mr. Johnson? Topic in this question. Mr. Johnson?
Oh, can you hear me now?
I can.
You hear me now?
I can.
Okay,
There's
okay.
an echo. Does somebody have?
It sounds like Tia joined, Your Honor.
I see that Ms. Johnson has joined, and yeah, I think she's got mute, so I think that will help. Try again, Mr. Johnson. Try again, Mr. Johnson.
The guys that you sent to the property, you didn't ask him to pick up anything or take anything with them?
No.
Okay. The guys that you sent to the property, you didn't ask him to pick up anything or take anything with them?
No.
Okay.
Mr. Freehoff, does somebody have it on live, or does somebody have it on YouTube, have the live stream open? Because that's usually what causes that sort of delay.
Yeah, I'm not sure, Your Honor, what's going on here.
Okay, well, as far as I'm concerned, I feel like you could probably end it. I don't know, or maybe restart it, but I can't. I can't live with that noise when I can't understand Mr. Johnson's testimony.
Understood. Are you asking me to end the meeting and restart it?
No. The live. I can't live with that noise when I can't understand Mr. Johnson's testimony.
Are you asking me to end the meeting and restart it?
No. The live.
All right. I've killed the YouTube, Your Honor. I will restart it now.
Okay. Try again.
Oh, fuck. I didn't know that happened. Excuse my language. Hold on while I find the rest of that. Give me 1 second. There was nothing after that. They didn't go live again. I promise. I swear. Oh man, I've rubbed my eyes because it's late. Listen, guys. I apologize immensely. There's literally nothing. Here, I like to share my sources with you guys. This is that page. It's Judge Rachel Krause. 178 subscribers. And she leaves stuff up for a little while. Not all forever, but she did. She does leave some stuff up. But there's nothing else. I don't know where they went. I apologize, but what is this one? That looks like another day. 3-hour hearing. Oh my gosh. Yeah, it's getting late though, guys. I thank you so much for being here. It's been 5 hours. How did that happen? My goodness. I appreciate all of you so much, all the members, all the supporters, everybody who's just chatted along with me and kept me company in the evenings and allowed me to keep you company. It's been fabulous. I appreciate you all. I will be back tomorrow with some more court that I will go find now. I thank you so much. I hope you have a wonderful evening. Please be safe, be kind to yourself, kind to somebody else, and have a good night, okay? I'll talk to you later. Bye, guys.